Off a day and good morning, everyone. The Committee on Justice is now called to order. Today is Wednesday, October 28th, 2020. The time is 9:07 a.m. Notices for this virtual public hearing were disseminated via email to all senators and all main media broadcasting outlets on Wednesday, October 21, and again on Monday, October 26, 2020. The notice was also published in the Guam Daily Post on those same dates. The general rules of conduct for this meeting adopted by the Guam legislature are: this Zoom meeting is hosted by the legislature's MIS staff, and I thank them for their assistance. The host will mute all Zoom participants until called upon by the chair. Individuals testifying shall first be recognized by the chair and begin by stating their name for record-keeping purposes. The order of questioning after testimony, will begin with the chairperson, followed by the panel of senators. Each member will be allowed to pose questions for each of the bills on the agenda today. Questions and testimonies shall be confined to the substance or nature of the agenda. The personal inference as to the character or motive of any senator or any individual testifying is not permitted. Any violations of this general rule of conduct will result in removal from the public hearing by the host. There are 4 agenda items today, 4 different bills. Bill 408-35 COR, introduced by Therese M. Terlaje, an act to amend Section 4401C of Article 4 of Chapter 4, Title 7, Guam Code Annotated, and to amend Section 40.50A of Chapter 40 of Title 8, Guam Code Annotated, relative to expanding the powers of the Superior Court of Guam magistrates to include the authority to preside over additional non-dispositive hearings and to modify bail conditions. Second item is Bill number 409-35 COR, introduced by Therese M. Terlaje, an act to amend Section 85.15 of Chapter 85, Title 8, Guam Code Annotated, relative to increasing the use of 6-member juries, except in cases where the defendant is charged with a first-degree or second-degree felony. Third item is Bill number 410-35 COR, introduced by Therese M. Terlaje, an act to amend Section 85.30 of Chapter 85, Title 8, Guam Code Annotated, relative to reducing the number of peremptory challenges available in criminal cases. The fourth item on the agenda is Bill number 411-35 COR, introduced by Therese M. Terlaje, an act to amend Section 80.60 of Chapter 80, Title 8, Guam Code Annotated, relative to extending the time in which a defendant must be brought to trial. I'd like to acknowledge this morning the presence of my colleagues, beginning with the Senator Pito Terlaje. Good morning, Senator. The Minority Leader, Senator Terlaje, and Senator Mary Camacho Torres. Good morning, Senators. Thank you for being here. I'd also like to acknowledge the presence of Justice Catherine Merriman. Good morning, Justice. Thank you for being here. All right, so we will begin right away. First, the item on the agenda, Bill number 408. And so before we hear from those who've signed up on the bill, since I'm the sponsor of the bill, I will introduce the bill very briefly. So I introduced this bill and the other bills that will be heard today on September 24th, immediately after receiving a request from Chief Justice Carbolito to assist the judiciary in resolving its backlog in cases due to the pandemic. In the Chief Justice's September 23rd letter to me, he wrote, quote, "As you are aware, since March 2020, in response to the COVID-19 global pandemic, Guam has declared Guam to be in a state of public health emergency. Since then, Hgca has issued a series of executive orders that have suspended non-essential government operations for the better part of the past 6 months. In parity with these executive orders and in recognition of the need to stem the spread of the virus, the Supreme Court of Guam has issued a series of administrative orders that have suspended non-essential court operations, including civil and criminal jury trials and grand jury proceedings for all but a few weeks in the last 6 months." He also states, "The suspension of non-essential court operations has resulted in a staggering and unprecedented backlog of cases, a backlog which continues to grow each day and threatens the statutory right of all criminal defendants to a speedy jury trial. Moreover, the current size limitations of judiciary facilities constrain the court's ability to safely and expeditiously recommence jury selections and jury trials in light of social distancing mandates and the legitimate health concerns of criminal defendants, attorneys, court employees, and those called to jury service. These constraints will cause further delay in the court's ability to tackle its backlog and will have lasting effects on the delivery of justice in all cases before the court. Therefore, the judiciary proposes the following statutory amendments, which aim to strike a necessary compromise between the rights of criminal defendants to a speedy trial, a speedy public trial, and the capabilities of the judicial system to carry out this duty during and in the aftermath of the COVID-19 pandemic. Additionally, the Judicial Council passed resolution number JC 20-026 relative to approving proposed legislation on the conduct of judicial proceedings for submission to the Guam legislature on August 20th, which included draft language. That must be September 20th, which included draft language that was used on the 4 bills that will be discussed today. Bill 408, the first bill on the agenda, will permanently amend statute to expand the powers of the magistrates to allow them to perform additional duties such as disposing of pretrial matters, issuing search warrants and warrants of arrest, performing marriages and hearing bail redetermination motions and modifying bail and conditions. According to the Bureau of Budget Management Resources, BBMR's fiscal note, quote, based on comments received from the judiciary of Guam, they anticipate Bill number 408-35 will not affect the revenues or the expenditures of their office. As such, the bill is administrative in nature and poses no fiscal impact to any funds of the government of Guam. So I'd like to thank the judiciary and the representatives from the public defender, alternative public defender, and the Attorney General's office who are here today. And I look forward to hearing testimony on this legislation. For the record, we have requested feedback on this bill from the Office of the Attorney General, Public Defender Service Corporation. We sent invitations to all members to the Guam Bar Association to be sent to all of their members, to the Department of Corrections, the Guam Police Department, Guam Coalition Against Sexual Assault and Family Violence, the Victim Advocates Reaching Out, and Guam Family Justice Center Alliance. So we will begin with Justice Catherine Merriman, Associate Justice of the Supreme Court of Guam. Justice Merriman.
Good morning, members of the legislature, Madam Chairman. I'm here primarily to assist if there's questions that arise. As you stated, these measures are supported by the Judicial Council of Guam and were developed by the judicial officers. But our court staff has prepared more detailed testimony. But if anyone has any questions, I'm available. Thank you.
Thank you, Justice Merriman. Thank you for being here and for being available for questions. We will proceed then to Attorney Christina L. Bard, the Administrator of the Courts.
Thank you, Madam Chair. I'm here to present the written testimony of the Chief Justice of Guam, Philip F. Carbolito, and I would like to read his testimony into the record. Before I begin reading that testimony into the record, I would like to preface his testimony with a note on the absence of oral or written testimony from other judicial officers. Canon 3 of the American Bar Association Model Code of Judicial Conduct permits a judge or a justice to appear at a public hearing before a legislative body in connection with matters concerning the law, the legal system, or the administration of justice. However, given the nature of the proposed statutory amendments before this body today, contemplated in this hearing today, and bearing in mind that issues concerning criminal defendants' constitutional and statutory rights often arise in cases before the courts, our judicial officers have respectfully declined to give testimony out of an abundance of caution to avoid future questions regarding their impartiality on these issues. Therefore, the Chief Justice, as the administrative head of the judicial branch of Guam, provides the following testimony on behalf of the judiciary of Guam. This written testimony will be provided to this legislative committee following the public hearing. Additionally, the Judiciary of Guam requests to submit technical markups to the bills following the public hearing. If I may be permitted to begin, I would like to read in the written testimony provided by the Chief Justice of the Supreme Court of Guam. It starts out with a greeting to our chair, Senator Terlaje, and states, "Thank you for the opportunity to present testimony on behalf of the Judiciary of Guam on bills numbers 408, 409, 410, and 411-35. The Judiciary of Guam has spent the last few months discussing and drafting the proposed legislation that is before this honorable body for public hearing today. These proposals seek to amend various statutory requirements governing judicial proceedings to allow the trial courts to efficiently and expeditiously resolve its backlog of cases. The proposals were approved for transmittal by the Judicial Council at its August 20th, 2020 regular meeting and were transmitted last month to your office, Senator Terlaje. I wish to extend my sincere gratitude, Senator Terlaje, for your prompt action in sponsoring these bills and scheduling them for public hearing. Since March 2020, in response to COVID-19 global pandemic, Governor Lou Leon Guerrero has declared Guam to be in a state of public emergency. Since then, the governor has issued a series of executive orders that have suspended non-essential government operations for the better part of the past 7 months. In parity with these executive orders and in recognition of the need to stem the spread of the virus, the Supreme Court of Guam has issued administrative orders that have suspended non-essential court operations, including civil and criminal jury trials and grand jury proceedings, for all but a few weeks in the last 7 months. The suspension of non-essential court operations has resulted in a staggering and unprecedented backlog of cases, a backlog which continues to grow each day and threatens the statutory right of all criminal defendants to a speedy trial. Moreover, the current size limitations of judiciary facilities constrain the court's ability to safely and expeditiously recommence jury selection and jury trials, given social distancing mandates and the legitimate health concern of criminal defendants, attorneys, court employees, and those called to jury service. These constraints will cause further delay in the court's ability to tackle its backlog and will have lasting effects on the delivery of justice in all cases before the court. Recognizing early on that COVID-19 was not likely to go away anytime soon, the judiciary wasted no time in springing into action. We procured software and equipment to outfit our judges with the tools necessary for remote hearings. With Zoom licenses, laptops, and webcams in hand, our judicial officers learned in a few short weeks how to preside over virtual courtrooms. But the nature of certain proceedings and the limited access to technology for many individuals who appear before the courts meant that virtual courtrooms were not enough. So we worked around the clock to retrofit our San Ramon building into a temporary, high-capacity courtroom where we could safely proceed with jury trials. Unfortunately, having just one space large enough for jury trials means that 7 of our judges must wait in line as trials are held one at a time. This will barely make a dent in the growing backlog of cases awaiting trial. Therefore, the judiciary believes certain statutory amendments are necessary to make a meaningful impact on the court's ability to address the current backlog of cases and prevent this backlog from continuing to grow at its current rate. These proposed amendments aim to strike a necessary compromise between the rights of criminal defendants to a speedy public trial and the capabilities of the judicial system to carry out this duty during and in the aftermath of the COVID-19 pandemic. Starting with Bill number 408-35, this bill seeks a permanent amendment to 7 Hgca Section 4401C to expand the powers of the magistrates to allow them to perform additional duties, such as disposing of pretrial matters, issuing search warrants and warrants of arrest, and performing marriages to ease the workload of the Superior Court judges so they can focus on dispositive matters. The bill also seeks a permanent amendment to 8 Hgca Section 40.50 to authorize magistrates to modify bail conditions. Bill number 409-35 seeks a temporary amendment to 8 Hgca Section 85.15 to increase the use of 6-member juries, except in cases where the defendant is charged with a first-degree or second-degree felony. This proposal, which includes a 2-year sunset provision, would allow for smaller juries in lower stakes felony cases. This would allow the court to reduce the number of potential jurors called for jury service, expedite the jury selection process, and ultimately result in a timelier resolution of criminal cases. Bill number 410-35 seeks a temporary amendment to 8 Hgca Section 85.30 to reduce the number of peremptory challenges available in criminal cases. The current number of peremptory challenges available to both sides in criminal cases greatly lengthens the jury selection process. Like the proposed amendment concerning jury size, allowing fewer peremptory challenges for a 2-year period would expedite the jury selection process and reduce the number of potential jurors who must report for jury services. And finally, Bill number 411-35 seeks a permanent amendment to 8 Hgca Section 80.60 to increase the speedy trial limits in criminal cases. Guam's current speedy trial limits of 45 days for in-custody defendants and 60 days for not in-custody defendants are among the shorter time limits in the nation. The proposed amendment would increase the speedy trial time limits for in-custody misdemeanor defendants to 60 days and for not in-custody misdemeanor defendants to 75 days. The proposed amendment would also increase the speedy trial time limits for in-custody felony defendants to 90 days and for not in-custody felony defendants to 180 days. These proposed time limits are based on the American Bar Association standards on speedy trial and timely resolution of criminal cases and are similar to the statutory speedy trial limits afforded to criminal defendants in many U.S. jurisdictions. In closing, the current surge in confirmed COVID-19 cases has put a heavy strain on the island's healthcare system and has resulted in an alarming and tragic rise in the virus's death toll. Given the likely timeframe for a vaccine, it has become increasingly clear that we still have a long road ahead in the battle against the virus. As I shared in my State of the Judiciary address in June, there is a myriad of issues following from this pandemic that have fallen and will continue to fall on the doorsteps of the court. Through the focus of today's bills is our criminal backlog. Though the focus of today's bill is our criminal backlog, the impact of this pandemic on the court's ability to safely execute its mandates extends to all case types and affects the thousands of residents who look to the courts to resolve their legal disputes. The judiciary trusts that our sister branch shares our interest in assuring the efficient and expeditious delivery of justice services to the people of Guam during these unprecedented and trying times. Thank you for your time and attention. Signed, F. Philip Carbolito, Chief Justice of Guam. That concludes the written testimony of the Chief Justice. Thank you.
All right, thank you, Attorney Barrett, and thank you to the Chief Justice for the testimony. We have signed up the Attorney Danielle T. Rossetti, Clerk of Court. Would you be presenting additional testimony this morning?
Madam Chair, I will not be. I will just be available for questions should the senators have any questions after the testimony has been received from everyone.
Okay, great. We also have then the Attorney General's representative, Attorney Shannon Taitano, Deputy Attorney General.
Day and good morning. I can read our office testimony into the record, if that's okay with you, Madam Chair. Thank you. Day senators and Justice Merriman, thank you for the opportunity to provide testimony on the subject bills. As an entity directly affected by court operations, we support all four of these proposals, which aim to relieve the operational constraints that have resulted from this unprecedented pandemic. We do respectfully make the following requests and recommendations for two of the measures. Bill number 410, we recognize that Bill 410 proposes to reduce peremptory challenges for the purpose of reducing the number of individuals called to report for jury duty and the time it takes to impanel a jury while maintaining fairness in the justice system. However, we request the following revisions to the proposed language in order to maintain parity in the distribution of peremptory challenges. Section 8.
I'm sorry.
5.
Shannon, forgive me.
Do you want me to?
Can we limit our testimony this morning, if as much as possible, to Bill number 408? And then because the committee reports on these bills will be separate, and so I want to make sure that they're included. But you can read the whole thing, but if you can divide it, that would be better. If not, that's fine.
Yeah, no, I could wait till we get to the measures that we have testimony for and wait until that time to read it into the record if that's what you prefer, Senator. And we have no specific comment on Bill 408, but as stated earlier, we do support the measure.
Okay, great. Thank you very much. We have signed up also Executive Director of the Public Defender Service Corporation, Mr. Stephen Attori, Attorney Stephen Attori.
Good morning, Chairperson Terlaje and senators and committee members. So the Public Defender Service Corporation, we reviewed this bill. We actually are in full support of the measure expanding the duties of the magistrate judge. The magistrate judge actually sets bail at the first hearing, the preliminary hearing, the initial hearing. We also call it the magistrate hearing. So it makes it's logical sense that he should be able to consider his own initial bail setting and allow us to modify it before it goes to the assigned judge. We also would propose an amendment that would allow the magistrate judge to also entertain a return of the indictment. Under Guam law, the magistrate judge can actually conduct preliminary examinations. And what a preliminary examination does, it does away with requiring 24 grand jurors to show up at court. All it is, it's a proceeding where the government prosecution would put on the evidence that they would present to a grand jury. Instead of presenting it to a grand jury of 24 and bringing all these people into close quarters in the judiciary, a preliminary examination is presided over by a magistrate judge. And we believe that the magistrate judge should be hearing these preliminary hearings. It would reduce the impact of COVID-19 on the court and the court employees who have to interact with 24 grand jurors pretty much 4 or 5 days a week. It will allow individuals represented by attorneys to have their attorneys present during these hearings, and it would really implement and provide the magistrate judge this additional responsibility. And so we think that the magistrate judge, if they're able to sit and preside over a preliminary hearing, they should also be able to entertain the return of a grand jury indictment. And so we support the bill, and we ask the legislature to pass it, and we hope that it's amended to expand the magistrate judge's duties to also hear the return of a grand jury indictment. Thank you.
All right.
We have
thank-
testimony on the other measures, but we will provide it when those bills come up.
All right, thank you. And is there anyone else at the Public Defender's Office that needs to testify right now? Are they available? Because I recognize there are several representatives. Zach Timon, the Deputy Director, John Morris.
Senator, Director Hattori's testimony sums up the position of the office on this one. We're in support of the magistrate's role being expanded. It has at times been challenging when he would make bail determinations and then felt that he didn't have the ability to revisit them at a future hearing. So I think this will specifically state what's needed.
All right, thank you. So we'll move now to the alternate public defender, Anna Maria Gail.
Good morning, Your Honor. Good morning, Madam Chairwoman. We support this bill as well. The preliminary hearing, as Mr. Hattori has said, is already in the statute, so you wouldn't have to make new statutes for that. We would just allow the magistrate judge to to go through with the powers that's already in the statute. So we agree with that bill, but would actually ask for it to be expanded to preliminary hearings. Thank you.
All right, thank you. All right, on this bill 408, is there anyone else who would like to testify? Attorney William Brennan.
Good morning, Madam Chair. I was listening online, and as I was reviewing this bill, I wanted to add another kind of concern that, at least in my practice, I've run into, although limited. But subsection or Section 2 purports to amend, or excuse me, Section 3 purports to amend Section 4050, which allows defendants to apply for redetermination within 24 hours. However, under the current rules and statute, there's no mechanism to get that before a judge in that same amount of time. So I think while this amendment proposal is before the legislature could also consider, if the magistrate is to hear applications to review bail conditions, some type of mechanism that allows the court to address it. Right now, the criminal rules just have an ad hoc process that was set up by the clerk of court in September 2016, I believe, that sets oppositions due within 14 days and replies 21 days from the date of filing. So while a defendant may apply for review within 24 hours, there's no guarantee that his motion will be heard until 21 days later, notwithstanding the 24-hour deadline was met. So that would just be something to consider since this amendment is before the legislature. That's all I have on 408. Thank you.
Thank you very much. Attorney Anita Arriola on Bill 408. Good morning. Please unmute. Yeah, can't hear you.
Thank you, Senator. I have no comments on Bill 408. I do have comments on some of the other bills. Thank you.
If there are no other testimony on Bill 408, we will now allow questions from the panel of senators. I'd like to begin. Can a representative of the court give us a breakdown of the backlog, what that really actually looks like for criminal cases?
Yes, thank you, Madam Chair. I would call on our Clerk of Court, Danielle Rossetti, to present the backlog.
Thank you for that question, Madam Chair. As our administrator of the courts presented when we had our budget presentation before the legislature a couple months ago, we were able to give some numbers on that. I will share with you since that time, during the start of the pandemic from March 17th or so to October 27th, we have had about 709 criminal case filings filed with the Superior Court of Guam. From January 1 to March 16th, there were about 309 criminal felony and misdemeanor cases filed. And in total, from the start of the year, January 1 to October 27, we have seen about 1,018 criminal felony and misdemeanor filings filed with the court. And on average, based on our case filings that we have annually, we generally will get the Attorney General's office. Typically, we'll file in the felony realm a little over 700 to 800 cases, and then in the misdemeanor, I think last year we saw pretty much around the same, so an average of about 1,400 criminal cases filed in a year, and we are in the last quarter of the year, and so we anticipate and project that we will likely have the same number of criminal case filings for 2020 that will need to be addressed before our Superior Court judges.
But have you been able to address any of these? So yeah, how many have you been able to address during these special circumstances? Or
yes, Senator. So in addition to the criminal case filings, what I will share is that the Chief Justice and the Supreme Court have issued numerous administrative orders allowing for the remote platform for certain essential and non-essential matters. And so in no means has the judiciary, while we may have been close to the public in March, a lot has been going on. We have had magistrate hearings. In July, we convened having arraignment hearings. We initially had a backlog of about 400, an average of about 400 cases that where defendants still needed to be arraigned. And in addition to that backlog and the additional criminal case filings, we are now down to about 175 cases that still need to be arraigned. And our magistrate judges have greatly assisted in that process, and all of the arraignments have been done remotely. Aside from the arraignment matters that have occurred in July, mid-July for about a month, the Supreme Court issued an administrative order that allowed for the reconvening of grand jury presentations by the Attorney General's office. And so in that short time frame, we were able to convene grand jurors 4 days a week and allow the prosecution division to present cases for throughout the day. And I believe we had almost 100 cases that were presented before the grand jury where indictments needed to be returned. There is, because of the continuing filing of criminal felony cases, we are seeing about a backlog of almost 300 criminal felony cases that still need to be presented before the grand jury. And again, I preface that because this number kind of fluctuates as felony cases are being filed. That number will change, and as the prosecution and defense need to work out specific plea deals in cases before they go before the grand jury, that number can also fluctuate. But generally speaking, those are the numbers that we are seeing right now. What is the likely result, of course, when a defendant is arraigned at such point as there probably will be some discussion later on the bill for a speedy trial timelines, is that when a defendant is arraigned, the defendant at that moment can assert or waive speedy trial just based on the assertions that have occurred as a result of the hundreds of arraignment hearings we have had by our magistrates since mid-July. We are anticipating, as of today, there are approximately 123 asserted trials that are before the 7 Superior Court judges. That is not, does not take into account the hundreds of cases where defendants have waived their speedy trial rights. And so we're about half. We have about 61 criminal misdemeanor asserted trials and 62 criminal felony trials that are before our 7 Superior Court judges. And that's, that's the information I have with respect to criminal case filings and the backlog before the Superior Court.
All right. Thank you, Ms. Rossetti. So for the backlog on the trials, this bill will not affect those. Is that correct?
No, that not with respect to trials. No, the bill will assist in other matters.
So the 175 arraignments, if this bill is passed, would the magistrates, would this decrease that backlog, or is it going to be status quo?
Because the magistrates already have the powers to conduct arraignments, both magistrates have worked together to decrease the backlog as best as they can. As you know, in August, mid-August, when the governor put us back into PCOR 1, we had to put a halt on the arraignment proceedings, notwithstanding that they were held remotely, but we have since resumed, and both our magistrates, primarily Magistrate Kwan, have been at the forefront with trying to reduce the backlog of arraigned defendants. But that's, we still need to proceed with the criminal justice process and get these defendants to trial.
Okay, and then so this bill is just regarding the magistrates, which cases they can handle. So the backlog on the grand juries, would that be reduced by this bill in particular?
I think the assistance that this bill would lend for the grand jury returns is, as Attorney Steve Hattori mentioned, the magistrates will be available to hear the grand jury returns from the grand jurors, such that the judges, the Superior Court judges, can focus on more substantive matters, such as if they were in the middle of a jury trial, they would be able to direct the magistrates to handle the grand jury returns. As it is now, if cases are presented before the grand jury, if a judge is the ex parte judge and the judge has to hear the return of the grand jury in any given day, the judge would have to stop the proceedings that they're in, and then they would have to hear from the grand jury foreperson, hear the return and the indictment. And so, it's a perfunctory process that I think the magistrates could assist in while the Superior Court judges are spending the substantive time that they need to carry the backlog for perhaps criminal jury trials or change of pleas.
And my only other question is for the second part of the bill that would allow for the magistrates to determine changes in release or release conditions. Right now, that's only a judge that is, I guess, by the statute allowed to determine a reconsideration of the release conditions. And, maybe a year ago, and of course, prior to that, there was really an uproar from the community regarding release of offenders, in particular on criminal sexual conduct, release of repeat offenders in certain types of crimes. And what assurance can you give that the magistrates are going to be accountable for these types of releases? I know magistrates are appointed differently than judges, and judges, as we know, are you go through a very extreme vetting process. They are affirmed, nominated by the governor, affirmed by the legislature, and they also, face the public every 7 years in a judicial retention election. But magistrates do not go through that type of process. They are appointed by, the courts. And so just want to hear, how can we assure the public that allowing the magistrates this ability to reconsider or to consider changes in bail or conditions of release would serve the public's interest.
If I may address some of your questions that you presented, this is Christina Barrett, the Administrator of the Courts. Senator Terlaje, the magistrates, when they first come in, they come before the legislature for confirmation. So they do follow a similar process as our Superior Court judges. And actually their vetting process is on a shorter period as far as when they have a similar proceeding to a retention. They're only for a 4-year period per statute. And when they come back in, that additional 4-year period is through the Chief Justice and also the Judicial Council. So when a magistrate is presented, as we just had with Magistrate Cison, that is a public forum that the magistrate is presented for another 4-year term. So there is perhaps from our eyes, a more stricter vetting of the magistrate judges because they don't stay in place for 7 years or they are only on a 4-year time frame. And as far as, if there's public outcry, which, we have to watch how we speak with that as far as actions on behalf of a judge, there is, both sides that are sitting here in this hearing today can bring, motions for reconsideration. That can be done in any proceeding. If there is dissatisfaction from either the prosecution side or the defense side over what happens to a particular defendant. Motions for bail modification, motions for reconsideration, or even violations on the part of a defendant can be brought at any time. So as far as particulars to a magistrate, we view the magistrate as actually being in a more stricter scrutiny of how they perform in their brief 4-year period. Thank you.
All right, thank you. And so would this apply to all cases, including any type of case?
I'm sorry, Madam Chair, may I speak?
Mr. Timinglo, yes.
Sorry, no, your previous question was about the magistrate's retention and the public outcry of certain persons getting released or not. I think that this bill would have more to do with Mr. Brennan's concerns raised earlier, the mechanisms of bringing forth before the court rather than the public view of things. So Mr. Brennan brought up the fact that a bail motion could be filed today, but probably won't be heard by the judge for another 21 days. This bill would potentially reduce that circumstance where on a magistrate hearing, the first appearance before a judge, for example, the magistrate would set a cash bail of, for example, $5,000. We here in our practice would probably have reached out to any persons named as a victim in that case and see what they want to see happen. If we come up with information for the court that the person named as a victim in the case may not oppose release, may in fact welcome release, as long as there's certain conditions on their behavior after that, we bring that up to the magistrate today, the magistrate will say, sorry, bring it up with the judge. And so I think that this bill would reduce that happening and would potentially, in time for the arraignment, we'd have a different set of information for the judge that was for the magistrate that wasn't there at the magistrate hearing. So I think that this bill is more of a mechanical thing rather than an exploration of danger to the community and flight risk. Thank you.
Okay, thank you, Attorney Timinglo. This Attorney Barrett, this would apply to, it looks like it's going to apply to all cases across the board, felony, misdemeanor. Is that right?
Honor. I'm sorry.
Yes,
Yes.
all criminal cases. Yeah.
Okay. All right. I just wanted to put those things on the record because I know that, so the timing of when bail conditions or release conditions can be reviewed, I agree with Attorney Timinglo, but I just also want to put on the record because, our role here is, to review these statutes, make sure that I know we have standards that are supposed to be used when persons are released, and danger to the community is of course one of them. So just wanted to be assured that yes, the magistrates will of course be held to the same standards and when reconsidering release. I couldn't find any real history that explained why they were allowed to consider conditions of release at first, but not reconsider them. So I'm just trying to flush that out. All right. Okay, so on bill number 408, I'm going to open it now to other senators for questions. Senator Pito Terlaje. Senator Pito Terlaje, if you could unmute yourself.
Can you hear me now, Senator?
Yes, I can.
At this point in time, I'm just trying to absorb all the amendments that are being made, and I know we're going to go over the amendments and have our colleague agree or not agree, but who knows more than the panel right now. So I don't have anything right now, Madam Chair. Thank you very much.
Thank you, Senator. Minority Leader, Senator Terlaje.
Thank you, Madam Chair, and to everyone who's here this morning, thank you for participating in these bills. Yeah, you're pretty much very thorough, Madam Chair, and asking questions. I thought it was important that the members of the public also understand the severity of the situation that we're in at the courts. So it was important that those numbers that was brought up by Danielle was very important for the public to know. But thank you. I have no questions at this time.
Thank you, Senator. Senator Mary Camacho Torres.
Thank you. I think this is a very good bill. It's certainly a bill that is appropriate for addressing some of the needs right now. And I thank everyone for providing information about it. I just want to also note that there are some minor technical and typographical errors in the bill that maybe the committee needs to just correct before this bill is reported out to committee, and I'll bring that up to the chair later. With regard to the uproar in the community, I think what we always have to be sensitive to is that oftentimes we become angry over matters that we perhaps don't understand the full facts of the matter. And with regard to the judges, we also have to recognize that there is a degree of judicial independence and discretion that we have to always afford them. So while we sometimes don't think we get what we believe is correct, we oftentimes have to yield to the judiciary as an independent body to flesh out the facts of the cases. And I just want to make that point, because we're, our uproar and anger is place. But with regard to 4.0, and I would certainly support it going forward.
Thank you, Senator. So in closing, on Bill 408, I'd like to thank the judiciary and the public defender and the Attorney General's office for their testimony in this regard. The pandemic is, of course, forcing us all to look at doing business, but this bill would be a permanent change and hopes to bring more efficiencies to the court, to relieve judges of certain duties, so that they can concentrate on those that they alone can perform. And so we do hope that this brings the efficiency, helps to reduce the backlog, and of course ensures continued trust of the public in the judicial system, and accountability of matters that occur there, particularly release. All right. We'll now move to the second item on the agenda, which is Bill number 410-35. It's an act to amend section 85.15 of chapter 85, title 8, Guam Code annotated relative to increasing the use of 6-member juries, except in cases where the defendant is charged with first-degree or second-degree felony. Again, I'm the sponsor of the bill, so I'll briefly introduce it. Again, this was introduced at the request of Chief Justice Carbolito and Judicial Council resolution to assist in resolving backlog of cases due to the pandemic. It will temporarily amend section 85.15 to increase the use of 6-member juries, except in first-degree or second-degree felony cases. Smaller juries for lower felony cases will permit expedient jury selection, possibly encourage a quicker resolution in criminal cases, while also reducing the number of potential jurors who must report for jury service. The amendments proposed in this legislation have a sunset provision and shall be deemed repealed 2 years after the enactment. According to BBMR's fiscal note, this will not affect the revenues or the expenditures of the judiciary. As such, the bill is administrative in nature and poses no fiscal impact to any funds of the government of Guam. So again, we will hear testimony from the panel, including beginning now with Justice Merriman or Attorney Baird.
Thank you, Madam Chair. Just for clarification, this is Bill 409.
Yes, yes.
Thank you. The testimony that the judiciary wanted to give on this bill has been presented by the written testimony of Chief Justice Carbolito. But both Ms. Rossetti and myself are available for any questions. Thank you.
All right. All right. All right. I'm sorry if I said 410. I'm supposed to say 409. Okay, so is there anyone else who would like to testify on this bill in particular? I have Attorney Rossetti, Attorney Hgca, Attorney Esbach, Attorney Stephen Hattori, Executive Director of Public Defender.
Thank you, Madam Chair. So today's hearings, we should just call this like an educational class on the 6th Amendment. And so at this time, I'd like to read that into the record. So in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of his accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So our office basically exists to defend the 6th Amendment. And while we're one line in the 6th Amendment, we have to defend the entire 6th Amendment on behalf of our clients. This is a very heady topic. We had a very short time to prepare something, so we will submit a more thorough and detailed position within the next 10 days. But we will state this for the time being, that we are opposed to a reduction in size of jury from 12 to 6 in felony cases. Courts around the country are dealing with this COVID-19 pandemic. I think we are the first jurisdiction to consider reducing in half the size of a jury. And the reason why we have a jury trial, I think nobody knows this more than the senators yourselves. Why do we have 15 senators instead of 7? It's because the collective wisdom of the 15 or before the 21 is much greater than the wisdom of a single person or of 6. And why do we have 15 senators rather than 7? Because it gives the public confidence in the process. The more diverse opinions there are, the greater the discussion, the broader the experience, the more faith the public has in the legislative process. The same thing goes for a jury trial of 12. If serious felonies, and I know it applies to 1st and 2nd degree felonies, but there are other felonies, third-degree felonies, terrorizing, involving a machete, that could get you 28 years in jail. So that's something that the public really needs to have confidence in, a full slate of 12 jurors. Now, Guam, we didn't always have the right to a jury trial. This was given to us in 1968 by an amendment to the Organic Act. Our predecessors had to fight for this right. And so we should not really take this bill very lightly. It should not be the first option to deal with this pandemic. It should be the last option. I know that we're all concerned about jury trials, calling jurors in, but there are many mechanisms across the country that different courts are using to deal with this exact problem. In the entire federal court system, all criminal cases where they're facing jail time of 6 months or greater, they all have jury trials of 12 individuals. And so the federal courts, we could look to them to see how they're handling it. If you, let me give you a perfect example. If you're charged with DUI on Anderson Air Force Base, you go to district court, you get a jury trial of 12. If you go to commit a DUI on the back road to Anderson, and you come before the Superior Court of Guam, you get a jury trial of 6. And so, I mean, there's even a question of whether, so at the federal level, through U.S. Supreme Court decisions, and I'll cite those in my written testimony, I don't want to bore everybody, but there's 2 classes of cases. One, serious offenses, which require jury trials, and in the federal system, it requires a jury trial of 12. And there was a recent Supreme Court decision that requires that be unanimous, that the jury of 12 be unanimous. And so it kind of suggests that you do need a jury of 12 for a serious offense. Other Supreme Court decisions say that you only need a jury trial if the punishment is 6 months or greater. And so, you know, that's another alternative we could do to really reduce the backlog. First offenders for DUIs, they never get a year in jail. I mean, you have to, if you commit the offense so severely that you're going to do a year in jail, maybe it should be a felony. So maybe first offender DUIs, we can reduce it to a petty misdemeanor and do away with jury trials completely for that. Family violence case, we had a program before called diversion. And in diversion, there's no admission of guilt. They get the treatment they need. And for first offenders, you're not facing deportation if there's no admission of guilt. So our brothers from the freely associated states, they're able to freely enter into the diversion program without fear of being deported. So if we go back to diversion, that's another way of easing this backlog. There are so many other alternatives. I can think of 5 places within walking distance of court where voir dire could happen. You know, there's the Guam Museum Theater. There's we have those, unfortunately, the movie theaters at the Ganya Shopping Center are vacant. You know, there's the Academy of Our Lady of Guam Gym. Even the atrium of the Superior Court is large enough to hold a jury selection. And there are other mechanisms they can use, like Zoom. We had a we had a staff meeting with 50 people in it. So it's not unforeseeable that you can't conduct it by Zoom, or you could do written questionnaires to narrow it down, and so that the pool will be much smaller. And so we just think that this is such a serious constitutional right that we hope that the legislature considers not approving the bill. We understand that it is only for a 2-year period, and we believe that the court has taken steps to basically minimize the risk. They've basically told speedy trial until the end of December, and so there is no sense of urgency to pass the bill at this time. I think there's many members of the bar who would also like to provide testimony, but because of the short notice of the hearing, they might not have been able to. I think the Guam bar notice just went out maybe last Friday. So, I mean, I know that other attorneys in our office might have things to add, and we'll submit a more thorough, detailed written testimony with all the case law that would bore you now if I had to cite them all. All right. Thank you for the opportunity.
Thank you, Director Hattori. Very much appreciate your analogy in that testimony, and of course, all of the testimony. We now would hear from Attorney Ana Maria Gail.
Thank you, Madam Chairwoman. I agree with APD takes the same stand as public defender in this, and will be submitting written testimony. I don't have anything more to add to Mr. Hattori's comments. I do agree with him, though, that this was all these bills for the bar. We don't have I know that other Guam bar members are not on here, and I only see a few members, and I would request that some of these bills, especially the ones that involve Sixth Amendment rights, that you put them on the side for now and maybe have a round table and we can discuss these measures, especially given that they affect the Sixth Amendment right of our clients. So that's my suggestion, is to put them on the side. The ones that involve the magistrate judge, we don't have any objection to that, but the other ones, I'm sure the Guam bar members would have a lot more to say than us. Thank you.
All right. Thank you very much, Attorney Gail. I appreciate that testimony. Shannon Taitano, Office of the Attorney General.
Our office supports the Bill 409. We don't have any specific comment on the measure, but just want to note for the record that we do support the measure. Thank you.
Thank you. On Bill 409, Attorney William Brennan.
Thank you, Madam Chair. I just wanted to raise again, and I think we will be submitting a written testimony as well, but just two issues. One, Section 8515 does retain a lot of similarities to the Federal Rule of Criminal Procedure 23B, notwithstanding there was an amendment. And I think the bill just doesn't do enough to demonstrate the intent of the legislature in such a significant deviation. And it's significant because right now we can look to federal cases interpreting Rule 23 to guide the Guam courts and to give some foundation, but this deviation without any reference to where the judiciary proposes this language from, and whether this is just because of COVID and the size of courtrooms, for example, we will essentially be building from scratch. And the concern also, the second concern I have is the sunset provision. I think it needs to more expressly address what happens on the last day of that second year. If the backlog is as severe as the court suggests, there's no way we're going to clear that backlog in 2 years. So if on the first day of year 3, I see this statute being ripe for a due process challenge, because you potentially have 2 sets of rules for what a first degree and third degree felony jury will look like. And I'd litigate that if I had a client who had that type of challenge available to him. But if the sunset provision needs to better address what happens if nothing happens at the end of that 2-year period, what rules apply and when they apply and to whom they apply. That would be the 2 concerns, other than just generally, as a defense attorney, I oppose this bill.
Thank you very much, Attorney Brennan. Attorney Anita Arriola on Bill 409.
Thank you, Senator. As Mr. Brennan stated, he is an associate at our firm. Our firm represents a number of criminal defendants, and we are opposed to Bill 409. As Steve Hattori said, he thought this was the first bill from any state or territory that was going to restrict the rights of defendants during this pandemic. I actually did a search and a review on the internet to find out whether or not any other state or jurisdiction is doing the same thing that Guam is doing, and I could not find any. This is a bill that so drastically changes the law on Guam that I would ask all of the senators and the entire Guam legislature to think very carefully about what they're doing before they even entertain or consider this bill. This is a bill that during a pandemic seeks to restrict defendants' rights rather than protect them. During a pandemic or any emergency or any crisis, the government and particularly the legislature should be looking at protecting people's rights and not restricting them. I totally agree with Mr. Hattori's statement that this is a restriction of defendants' rights because a jury of 12 is much more preferable in terms of protecting defendants' rights than a jury of 6. The intent provision of this bill states that the ensuing backlog of criminal cases threatens the statutory right of all criminal defendants to a speedy jury trial. I would amend that to state that the ensuing backlog of criminal cases left unresolved by the court and the Attorney General of Guam threatens the statutory right of all criminal defendants to a speedy jury trial. And what I mean by that is jurisdictions around the country, particularly the state local courts that have to deal with criminal cases, are finding innovative and creative ways to deal with this pandemic, but they are not restricting the rights of defendants to a jury trial of 12. They are not restricting the defendant's right to a jury trial and restricting the number of jurors. Instead, they are doing things like finding larger rooms, larger auditoriums, larger places and conference rooms where they can hold hearings and they can hold jury selection. For example, I have a good friend in the Superior Court in California, Judge Brad Seligman. Instead of calling jurors in to do voir dire, they are now doing it on Zoom. And he tells me some funny stories about getting people in bed, who are waking up, but they're on Zoom because he's doing voir dire with them. But, this is the kind of creative and innovative ways that our court needs to think about in terms of protecting the rights of defendants. We need to figure out how we're going to get these jury trials going because, I agree with my associate Bucky, we're not going to get rid of this backlog by simply reducing the number of jurors in a criminal trial. We're going to reduce them by getting these trials up and going. We've done this before in other cases. For example, the Royal Palm Resort trial, certainly that was not a pandemic, but where we had, hundreds of witnesses, tens and dozens of parties, and we put them up in a big conference room at a hotel where we were able to do that trial. In the Tory trial, we are now ensconced in a room that is large. It has distancing for the public, for the jurors, for the court, for the attorneys. So there are ways that this can be done. We just need to be creative and we need to think about how these jury trials can be done. In addition, we need the Attorney General's office to work with the Criminal Defense Counsel. We need them to come forward and tell us, do you have a plea agreement where we can get rid of these cases? As Mr. Hattori said, do we have diversion programs so we can get rid of some of these cases? We are really kind of on hold right now because we're unable to get a hold of prosecutors. They're not answering our phone calls. They're not returning our phone calls. They're not answering our emails. We don't know where they are. And so it's a situation that doesn't just involve the legislature passing bills or the court coming up with creative ideas. It's also the Attorney General's office that needs to come forward with answers and responses to our requests for plea agreements and for diversions. That's how we get rid of this backlog of cases. All of us need to work together. And so, Senator, we're opposed to this bill. If you have any questions, I'm happy to answer them.
Thank you very much, Attorney Ariola. Appreciate your testimony. Mr. Tamanglo, do you want to testify on this bill, Attorney?
Yes, Madam Chair. Thank you. I have two concerns. I used to work at the courthouse. I was a law clerk previously before I came up here and before I joined Ms. Ariola at her firm. When I was a law clerk, our office was right across the jury room, and nothing made me sadder than watching a jury pool crammed into that room with minimal noise, minimal water breaks, sharing 2 bathroom stalls for 200 people. My first concern was another alternative to reduce backlog and increase the ability and availability of the court is to ensure that the courthouse gets the resources they need So we can be creative with this resolution. So I would, of course, echo what Mr. Hattori and Ms. Ariola said previously. My second concern is that the AG's position that they support it without more is concerning. It's supposed to be hard to convict people criminally. We have the highest burden of proof. We require the most jurors. It's supposed to be hard because everything that's being said in court is being said about an innocent person, and we can't forget that. So I would also oppose this bill.
Thank you very much for your testimony. Is there anyone else who I haven't called who wanted to present testimony on Bill 409?
Madam Chair, I had a couple of brief points if I could.
All right, Attorney Morrison.
Thank you. I wanted to point out first that I'm looking at ABA standards right now, and standard 15-11, right to a jury trial, recommends that people receive a jury of 12 unless the penalty is 6 months or less. So currently, if we change nothing, Guam is falling below that standard. I also wanted to point out that part of the legislative intent in finding part of this bill references lower stakes felonies. And I know we all know what's meant by that, but I wanted to point out that there are felonies that if someone's convicted of will cause them to lose any public assistance, will cause them to be kicked out of their home if it's federally or locally subsidized. Asylum claims will be turned down. There are deportation consequences. So there are a lot of consequences that stem from lower stakes felonies. And I'm sure for those people, they don't feel like lower stakes felonies at all. I wanted to just kind of tell the legislature what I'm experiencing as far as the backlog myself. Currently, I have a lot of cases that are involve the possession of a controlled substance. And I have not felt that there is an incredible uptick in the number of people that want to go to trial on one of these types of cases. What's happening is that they're just slower to resolve right now because a lot of things have to take place before we can get that case into court to be heard. Even if everybody comes in on day one and agrees that this is a case that should be in our drug court, the process of getting the defendant in there is still going to take months currently. So what has to happen is the prosecutor has to review the file and determine that if the person is legally eligible to be in the program. Then probation has to meet with the person and decide if they're clinically eligible to be in the program. If all that goes well and the person's eligible, then we have to get the plea agreement, which is a 15 or 18-page document that's generated by the prosecutor. And that's taking a lot more time than it has historically at this point to get that document. But the problems don't end there. We still have to get the document out to our client at DOC if that's where they're at. So now there's a completely different process for doing that, getting it signed off on, if there's an interpreter that was needed. Each aspect of this is slowing things down. And I think Ms. Ariola was correct. We need to be creative. It's not that everybody is sitting there saying, you know, now that we're in this pandemic, I want more than anything to get my case in front of a jury. There are some people that want to have jury trials and they should be afforded that right. But I think by and large here, this backlog will go away the day we can operate again, or when we get a system in place that will allow for speedier resolution.
All right, thank you. Appreciate that. Would the Attorney General's office like to comment in response to any of this testimony?
Thank you, Senator Terlaje, for the opportunity to respond to some of the comments. Again, we support the legislation and understand the court's need to make this amendment or suggest this amendment to the legislature. We have in office our prosecution division, but we are limited physically by the executive order to reduce the capacity in our office. But many of our attorneys and staff are working remotely, including answering phones and trying to respond to emails. But I will note the comments made today, and we'll talk to our chief prosecutor to find out if there are any issues with our phones or responding to emails, and hopefully be able to resolve that if that is a real issue that's going on in our office. But other than that, we still remain in support of Bill 409.
All right, thank you.
Oh,
So,
Madam Chair, could I?
wait, who's talking? Attorney Hattori. Yes.
So Madam Chair, I mean, I understand that the court believes that there is a backlog, but I mean, I think many of the defense attorneys and some of them may agree with me that so what's happened is that because speedy trial's been told till the end of December, there's neither a benefit nor a detriment to asserting your right to speedy trial. So many of our clients are just asserting, hoping that we can resolve the case quickly. So the backlog is not created at the court end. It's more like, you know, if we can get plea agreements. And we are resolving a lot of cases in drug court and in DUI court and certain other courts, but there is many of our clients really, they have no intention of going to trial. A lot of them, Guam's a remarkable place because people accept responsibility and they often confess. And so they want to start their cases sooner as opposed to later because they don't get credit for checking in 3 times a week pre-trial. Their probation doesn't start until they actually enter a plea. So a lot of them just want to get their cases wrapped up quickly. We don't really foresee a larger than normal number of trials. In fact, if you look at the historic numbers, right, the number of cases have gone down significantly over the last 5 years. This year is no different. We're probably about 100 misdemeanors less than we were this time last year, and felonies might be 75 to. We're tracking to have the lowest number of misdemeanors in the history of Guam, and we're also probably tracking to have the lowest number of felonies in the last 5 years. So there really isn't. It's just a matter of resolving the case, and I think, you know, we're working with the government to try to do that, and with the court we've offered to waive grand jury and let our clients plead guilty to an information because there's no benefit to them of a grand jury and they just want to go into probation. They've not taken us up on those offers, and that would save 24 jurors from going to court, meeting in a courtroom to decide whether an indictment should be issued. But our clients like, I want to get treatment, I'm willing to waive a grand jury, I'll plead to an information, and that, you know, that offer hasn't been accepted. But we'll continue to try to cut down this backlog for the court, and so we're trying to work with the AG's office on that. Okay, thank you.
I appreciate the testimony, and I will definitely take all of it into consideration. Sorry, Attorney Baird, yes, did you want to add to this?
I would like to add just some clarification, just so that this body is fully informed. So I do want to put in the record that a 6-person jury trial is not unusual.
Can't hear you. I can't hear you right now. Attorney Baird, I can't hear you.
I think your MIS needs to unmute me.
There you go. I can hear you now.
Okay, thank you, Madam Chair. I just want to make sure there's some clarity here on the record. A 6-person jury trial is not an unusual thing. In the CNMI, there are juries of 6 for all criminal cases. This is even before the pandemic. In Connecticut, there are juries of 6 for all criminal cases, except those in which the defendant faces death or life imprisonment. Florida requires juries of 6 for all criminal cases, except when the defendant faces death or imprisonment. Same with Indiana, Louisiana, and Utah. So a 6-person jury is not, first of all, an unusual thing, and other jurisdictions most certainly have those provisions. As far as the pandemic, just for clarification, Massachusetts, during phase 1 of their COVID-19 reopen, will permit only criminal jury trials of 6. This is taken from their 4th updated order regarding court operations under the exigent circumstances created by the COVID-19 pandemic dated September 17, 2020. So this measure is being considered. Guam is just a little in the forefront with this, being the 2nd jurisdiction to request or put this forward. So they're not unheard of measures. I do also want to point out that the suggestions over facilities, and I know there was a reference to the Royal Palm litigation. And if my memory serves me correctly, I was here in Guam then, that place was paid for by the parties. That was not something that the vendor just offered up that venue for that case to take place. What's being overlooked here is in a criminal jury trial, there is an insurmountable amount of security for the protection of all of the individuals that are on the screen that appear before the court, the protection for the public, the protection for the victims. We require martial protection and some very heavy security measures when we have criminal jury trials. So we just can't walk into a theater or an open building and set up a criminal jury trial. It's not that easy for the judiciary to do that. So while those suggestions are noted, these are measures that the judiciary has been struggling with for the past 7 months, trying to figure out how we can get our criminal jury trials safely put in place, and the safety is for all parties involved. So the difficulties of a place don't just start with finding it. And without all due respect to the legislative body, as you well know, we are under a very tight budget this year. So going out and renting a space, not just the security is an issue for us, but the funding is also an issue for us. So it's not something that we can do at the snap of a hand. Right now, our facilities, as they stand with the space that we have one courtroom that is currently available to conduct criminal jury trials. Our other spaces do not meet CDC or Guam Public Health measurements and safety that they require for participants, vendors, the parties to be 6 feet apart. So we're strapped with that. And right now, this measure in front of the body, it is not an unusual measure. It's something that's done in other jurisdictions. It's something that's being done in the response to the pandemic in the state of Massachusetts. And it's something that Guam is putting forth, the Supreme Court, the Judicial Council, as a measure to try and address backlogs. And it's only for a 2-year period. So I just want to add that clarification, and I thank you for the opportunity.
Thank you. Attorney Barrett, could you just clarify on the judiciary side, so you discussed that there is one courtroom that you have set up to meet CDC standards to conduct jury trials of 12-member juries. Are there any plans to add on to that capacity?
The plans right now are for 2 other facilities to be put into place as another high capacity courtroom. The construction takes time. Right now we have the Route 4 building that we're looking at. It is currently, as we speak, under renovation. In addition, the 8th courtroom that used to hold our MIS division is under renovation to try and make these, both of those facilities, high capacity courtroom number 2 and high capacity courtroom number 3. Our contractors and the way that the work is proceeding, that probably is not going to take place until January, February.
Why is that? Construction is one of the exemptions on.
Well, Madam Chair, as far as the 8th courtroom, it houses our servers right now, and to move servers is a huge endeavor. These are our servers that support our case management system, our security systems. That alone is probably going to take us, just to move the servers out of that 8th courtroom right now, is going to, I'm guessing, probably not take place until December that we would move. Then we would need to reconstruct it. As far as the Route 4 construction, right now that construction is ongoing with a hopefully the end date of just the shelling being that it doesn't have walls in some areas, it doesn't have windows in some areas. So once we get the shelling done in December, then we'll turn back in to place our second, hopefully high capacity courtroom. We also have a permitting process. While construction is not delayed, we still must go through the permitting process. We experienced significant delay in the Route the San Ramon building reconstruction with permitting. So just to run our fiber optic permitting took almost a month to get that permit. So we have, as with, even though construction may be ongoing, all of the intricacies that surround a construction project do present delay for the judiciary.
All right, thank you very much. Again, thank you to all on the test, Attorney Ariola.
Thank you, Senator. I don't want to get into a tit for tat here thing, but I just want to clarify as well that when Ms. Baird talked about the situation in Massachusetts, if you go online, you can find that they are doing a phased recommencement of jury trials beginning in October and November. They didn't restrict the number of jury trials from 12 to 6 as we are doing with this legislation. Phase 1 is going to begin jury trials of 6-person jurors as to particular cases in only certain locations in that state. But it is not a bill that was passed, and it's not an order that is being passed to restrict from 12 to 6 as we are doing here. In terms of the facilities that the court has, it's true that the Royal Palm case, the facilities were paid for by the parties, but that is what I would expect from the court in this case. I would expect that they would come to the legislature and say, we need some money. We need some resources to help us with trying to get jury trials on the move and to cut this backlog of cases so that we can either rent rooms or find other places to get these jury trials going. I don't expect that they would instead try to restrict jury trials. And those are the only points I wanted to make. And then just the final point that, when Ms. Baird talked about 6-person jury trials being uncommon, I counted 4 jurisdictions, so it's not, it may not be uncommon, but it's not widespread.
Could I,
Thank you.
Could I add one point to Attorney Ariola's comments?
All right, one point, and then all other testimony you can submit by November 6th, please. All members of the Guam Bar have been invited, and I will remind them again that they are welcome to submit testimony by November 6th. But Attorney Morrison, yes, one more.
Thank you, Senator. I also wanted to point out that in Massachusetts, it seems to be a phasing in approach, and it looks from my limited research that the juries of 6 are only permitted with the consent of the defendant. So I think that's something to consider there. Thank you.
Sure, and so I very much appreciate testimony regarding the 6th Amendment right. I do not want to impede that, and of course, so I will be looking at these bills again, this bill especially, and I would like to suggest that the Attorney General's office and the courts pretty much flesh out, alternatives, if there are any, before we go down this path, and that so that we only take this type of action if all other alternatives are just simply not available. And I've heard some, I think, good suggestions, and if we could especially take a look at those and just submit some testimony as to why those are or are not possible in these cases. And if, but I think there have been some very good suggestions. All right, so I'm going to open up to the panel of senators for questions. Senator Peter Terlaje, do you have any questions on Bill 409?
Thank you very much, Madam Chair. And I just want to thank the panel for their input. I'm hearing opposing testimony to Bill 409, and I hear supporting testimonies. And I guess the Bill 409 is reflective to actually the restriction that, on the defendant's right. So we need to think about that. And we need the senators to really come down with and review all the written testimony to make that determination. And one thing that I want to say, that diversion would be a program that would solidify some of the problems that we have. And that, Madam Chair, that is all that I have to say. And I want to thank the panel again for their input. Thank you very much.
Thank you, Senator. And Minority Leader, Senator Taitabu.
Thank you, Madam Chair. It's giving me also the opportunity to look through the website on some issues. But I think Attorney Gail had it right when she said that we should have a round table I think if we can go all day on this and bring more people to the table to discuss the merits of this as well. So I think a small group like this is not enough to really come to a consensus. Thank you.
Thank you, Senator. Senator Mary Camacho Torres.
Thank you. I have a question to Christina Baird or to Danielle. It's a very short bill. It's really only 12 lines where it's amending section 85.15 regarding 6-member juries. But in reading this, please correct me if I'm wrong. Are we? It doesn't eliminate the entitlement of the defendant to a jury of 12. Correct? That request still is preserved by section, I believe. And where it goes to 6 is if the charges, if it proceeds to trial with lesser charges that would have been a jury of 6 to begin with. But the question is, this I keep hearing that, a jury of 12, there seems to be discussion about a jury of 12 not being the number now. But in reading this section, it appears that the defendant shall be entitled to a jury of 12 upon written request filed with the courts. So that part is still preserved, right? It's not an automatic in first degree and second degree felonies.
That's correct. Sorry, Dania. That's correct. It's for the way the bill reads in the first sentence. The second. The first degree or second degree felony still retains the right to the jury of 12. That's correct. So when we talk about the cases that would be impacted, it's more of the third degree felonies, which are the criminal mischief cases, the theft, criminal possession, escape, forgery. It's more of those. The third degree felony cases include those. But the right to the jury of 12 is not lost in this proposed amendment. That's correct.
And I will add, Senator Torres, to Ms. Baird's comments. Most of the cases that go to trial are first and second degree felonies. Anyway, so first degree criminal sexual conduct, second degree criminal sexual conduct, burglary, aggravated assault, those are all first degree felonies and second degree felonies. So the defendant in those cases already have the right to a jury of 12. The proposed legislation would affect the cases where there are third degree or less felony charges.
Okay, no, that was the only clarification that I wanted, because it didn't sound that way just with the discussion that was being presented, and that's all. Thank you very much. A very, very healthy discussion.
Thank you, Senator. Attorney Rosette, can you tell us how many cases that might impact then, the number?
So, Senator, on average, we typically, for cases that go to trial in any given year, it could range from 50 criminal trials to about 65 criminal trials. And just I believe in 2019, for calendar year 2019, we had almost 65 cases that were presented and ready to go for trial. And more than half of those cases were first and second degree felonies. And when I say cases that were ready to go to trial, because of the nature of our criminal process, a defendant can assert and waive and take the plea even at the last minute, even after trial has started. And so in some of those cases, when I provide those, give those numbers, in some of those cases, while it may have been a first degree criminal sexual conduct case that was ready for trial, we summoned the jurors, we were ready to start, the defendant took a plea, we count that as, ready for a jury trial. But just based on the cases that come before the judges that go to trial, those are the types of cases that really proceed to have jury selection and trial. And when this occurs, on any given criminal case that is brought before the court, we typically bring in about 80 to 100 jurors to fit in our jury assembly room. And so that, because of the pandemic situation and in order to meet the CDC and public health guidelines, that number will be significantly reduced once the court starts to resume jury selections and trials. What used to be a room that held 80 potential jurors is a room that can only hold 16. We are utilizing other areas of the courthouse to accommodate at least 35 jurors to come in for just the jury selection process and not the jury trial. So again, there will be some delays in the judges presiding over the jury selection. What normally would take a couple of hours in a day for a trial before a judge will take a little longer because we have to also balance the safety of the jurors. And you know, I would also just add, with all these bills that are before the body, you know, the judges and the management team and our Chief Justice, we have been at the forefront of trying to help keep the wheels of justice turning with this pandemic. It's something that is new for all state court jurisdictions. There's only a handful of state court jurisdictions that are starting to resume jury trials in a phased-in approach. And we have been trying, you know, tirelessly, trying to see what other court jurisdictions are doing, sharing our thoughts. Judges have been having more remote hearings to try and close and bring matters to resolution, because we all know that once the tolling of the speedy trial is lifted, is no longer there, we have to be ready to proceed forward. And so it's a constant dialogue that our Chief Justice has with our judicial officers. And it's, you know, that's what we're doing now. So we appreciate all the comments from those that are present too.
All right. So the approximately 50 or 65 cases that you said you estimate go to trial, half of those are third-degree felonies? How many of those are third-degree felonies? How many are impacted?
In 2019, we had almost 65 jury trials, and about half of them were first and second degree felonies. The remainder were third degree felonies and the misdemeanors.
All right, and the existing courtrooms are able to be utilized for 6-person juries?
Correct.
All right, so the challenge remains jury selection, right, delays just because of facilities, and also just the facility for 12-person juries. But the 6-person juries, are those going on right now? Are you holding those to relieve some of those cases?
So under the Supreme Court administrative order, the trial judges, upon approval by the presiding judge, have the authority or the discretion to review the matters and to proceed with having criminal misdemeanor trials. And so our judges, and that just was something that could have started, gave them the authority in a few weeks ago. So I think, or just last week actually, I think our judges are taking a look at their dockets to see if the cases really are ready for trial, our counsel's ready for trial, and trying to schedule out their criminal misdemeanor trials. So we do anticipate that we will have some criminal misdemeanor trials scheduled.
All right, okay. But currently you're not aware of any that are actually ongoing or have begun since the March?
Madam Chair, the only trials that have resumed since the start of the pandemic have been the trials where jurors have already been impaneled. So we had one judge already impaneled 2 juries and 2 jury panels, and in 2 cases, and those cases were proceeded to the end. And then we have one judge presiding over a panel now where the jurors were already selected and the trial had already resumed. So those are the 3 cases that have started since the pandemic, but no new jury selections and trials have occurred.
All right, okay, thank you very much. I'm going to move on to the next item on our agenda. Bill 410, introduced by Therese, an act to amend section 85.30 of chapter 85, title 8, Guam Code annotated, relative to reducing the number of peremptory challenges available in criminal cases. Again, like the other 2 bills, this was introduced at the request of Chief Justice Carbolito to assist the judiciary in resolving its backlog in cases due to the pandemic. The bills were included in the Judicial Council's resolution number JC 20-026 which was adopted on August 20th, word for word. Bill 410 would temporarily amend statute to reduce the number of peremptory challenges, where the offense charge may be punishable by a sentence of 15 or more years of incarceration. Each side is entitled to 12 peremptory challenges. Currently in statute, if the offense charge is punishable by a life sentence, each side is entitled to 20 peremptory challenges. Otherwise, the government is entitled to 6 peremptory challenges and the defendant or defendants jointly to 10 peremptory challenges. In the bill where the offense charge may be punishable by a sentence of less than 15 years of incarceration, the defense is entitled to 6 peremptory challenges and the prosecution is entitled to 3 peremptory challenges. Currently in statute, government is entitled to 6 peremptory challenges and the defendant or defendants jointly to 10 peremptory challenges. In the bill, in any misdemeanor or petty misdemeanor prosecution, the defense is entitled to 2 peremptory challenges and the prosecution is entitled to 1, compared to current statute where each side is entitled to 3 peremptory challenges. If there's more than one defendant, the court may allow the defendants additional peremptory challenges and permit them to be exercised separately or jointly. In the bill, for any criminal prosecution where there's more than one defendant, the court may allow the defendants additional peremptory challenges and permit them to be exercised separately. The idea is that fewer peremptory challenges will permit a quicker processing in selecting the jury, reducing the number of potential jurors who must report for jury services. That's the theory. And BBMR, again, on this bill has said that, and this bill, will have a sunset provision repealed after 2 years. It's strictly supposed to relieve, jury selection or the amount of jurors during this health pandemic. BBMR's note said that this bill would not affect the revenues or the expenditures of the judiciary, and thus is administrative in nature, poses no fiscal impact to any funds of the government of Guam. All right, so we will go straight into testimony. And again, if I could just state for the record on this bill, we requested feedback from the Office of the Attorney General, Public Defender Services Corporation, Guam Bar Association, Department of Corrections, Guam Police Department, Guam Coalition Against Sexual Assault and Family Violence, Victims Advocates Reaching Out, and Guam Family Justice Center Alliance. So we will begin with the court. Would that be Attorney Baird?
Thank you, Madam Chair. Can you hear me?
Yes.
Okay. As stated before, our written testimony from the Chief Justice is the testimony that we'd like to provide at this point on this particular bill. Thank you.
All right, then we will proceed to the Attorney General's office. Ms. Shannon Teitzman.
Thank you. I'll just go ahead and read our written testimony into the record on Bill 410. We recognize that Bill 410 proposes to reduce peremptory challenges for the purpose of reducing the number of individuals called to report for jury duty and the time it takes to impanel a jury while maintaining fairness in the justice system. However, we request the following revisions to the proposed language in order to maintain parity in the distribution of peremptory challenges. I'll just go ahead and read the amendment, our proposed amendment to the language in the bill in section 85.30. In any felony prosecution where the offense charged may be punishable by a sentence of 15 or more years of incarceration, each side is entitled to 12 peremptory challenges. In any felony prosecution where the offense charged may be punishable by a sentence of less than 15 years of incarceration, the defense is entitled to 6 peremptory challenges, and the prosecution is entitled to 4 peremptory challenges. In any misdemeanor or petty misdemeanor prosecution, each side is entitled to 2 peremptory challenges. In any criminal prosecution where there is more than one defendant, the court may allow the defendants additional peremptory challenges and permit them to be exercised separately. Existing law allows a ratio of 6 to 10 peremptory challenges, prosecution to defense in lower level felony cases. We request that the proposed changes allow the prosecution 4 peremptory challenges to maintain a more equitable baseline ratio of 4 to 6. This will become especially important in cases involving multiple defendants in which the court may grant additional peremptory challenges to the defense, while the prosecution will be limited to the statutory level. In misdemeanor and petty misdemeanor cases, existing law allows 3 peremptory challenges for both the prosecution and defense. While we support the temporary reduction in the number of challenges, we request that the parity in the current law be maintained and that 2 challenges be permitted per side. But other than that, the recommended changes to the current legislation, we do support Bill 410. Thank you.
Thank you. So just to clarify, the proposed amendment by the Attorney General's office is where the prosecution is entitled to 3 peremptory challenges. You would like that to be 4, and where for petty misdemeanors or misdemeanors, the prosecution is entitled to 1 peremptory challenge. You would like that to be 2.
Oh, sorry, I'm not sure if you heard me earlier, but yes, that is correct.
All right, thank you. All right, Attorney Hattori, Executive Director, Public Defender.
Thank you. Chairman, we'll submit written testimony on this, but I do want to attack the premise of the bill. This will not expedite voir dire. So currently, when you pick you go through jury selection process, right? And we're trying to get an impartial jury. There are 2 ways of getting a juror off. One way is through moving to recuse them for cause, which is a very complicated and long-winded process. And the other is peremptory, where you just call out their juror number. You don't have to explain. As long as it's not based on discriminatory reasons, you can exercise it. So what's going to happen is, if we reduce the number of peremptories, there will be an increased amount of recusals for cause, thereby extending the process of voir dire. It also creates more appellate issues. Like, I had this one trial where 2 employees of the AGs I tried to remove them for cause. The judge wouldn't let me remove them for cause. They finally sat in the panel of 12, and I asked them, like, well, if your brother were charged with a crime, would you want an employee of the AG to sit as a juror? And they said, absolutely not. And so I used my peremptory challenge on them. But if I had not used my peremptory challenge because I didn't have one, that case, if there was a conviction, would have been reversed on appeal. And so peremptories are efficient. They're much faster than trying to DQ a witness for cause. And I think it'll actually extend the process. Maybe the other attorneys would give their opinion as well. But we'll submit something in writing. Thanks.
I appreciate that. Anna Marie Gail, Alternate Public Defender.
Thank you, Your Honor. Senator Terlaje. I agree with Mr. Hattori. We'll probably just submit written testimony, but I agree with him. It'll make the process a lot longer if you have less. Thank you.
Attorney Ariola.
Thank you, Senator. I don't really understand this bill, because I don't understand how reducing the number of peremptories for attorneys is going to reduce the backlog of cases. We're still going to have the same number of jurors coming in, the same number of jurors being challenged, whether it's peremptory or with or without cause. And so I don't see how this furthers the intent of reducing the backlog of cases. As Mr. Hattori said, peremptory challenges are done pretty quickly. They're easily done because you don't have to provide cause. It's a without cause challenge. And you can simply say, we exercise our peremptory on, juror number whatever, or the proposed juror number 4, 5, or 6, and then it's done. How can this reduce a backlog of cases? Thank you, Senator.
Thank you very much, Attorney Ariola. Attorney Taminglo.
Thank you, Madam Chair. I echo what's already been said, that peremptories are the speediest portion of voir dire. And we here in this Zoom hearing right now, we have an inordinate amount of attorneys in this. And so for the purposes of the record and for the members of the legislature, which have no previous experience with this, when there is a for-cause challenge, generally speaking, it's been my experience where someone is saying all the right things to remain on the jury. They can be impartial. They will always weigh the evidence and not make an assumption ahead of time, but consistently gives me or my client very nasty looks at them, Baba, if you will. So I have to then use my peremptory challenge on that person because everything they're saying, swearing up and down that they will be impartial, may not be believable in practice. That is the speediest way to do it. Mr. Hattori is right. If we have to argue every single for-cause challenge, then that will drastically increase the length of voir dire. Thank you.
Thank you. Attorney Brennan, did you want to testify on this bill?
Thank you, Madam Chair. I would just echo the testimony of Mr. Hattori and Ms. Ariola. I'd only add the same issue about the sunset provision, what happens at the end of that period. And also, I just assume nothing when I read legislation. And when I read this, I don't understand the 15-year. It seems arbitrary, especially considering we have special allegations that could attach to felony charges. So what range are we using? Are we using the underlying felony for a first-time offender or the 5 to 25 years for a special allegation? And that leaves a huge ambiguity, which again, I would love to litigate if this language is passed as written, but that would be a concern that there are some terms that are thrown around here that really maybe unintentionally change the statute pretty significantly. So I think addressing and tying up some of those loopholes would be appropriate. We'll likely submit written testimony on this one as well.
Thank you. I appreciate that. Would anyone from the court like to speak on the 15 years provision? Where did we come up with 15 years versus any other type of sentence?
Thank you, Madam Chair, for the opportunity. Yes, as far as the court is presented through discussion, and the testimony of Chief Justice Carbolito, that we believe through our practice of holding these cases that this will expedite our jury trials as far as going through. As far as your question concerning the peremptory challenge legislation, we're following what 30 other United States jurisdictions do, including the CNMI, Alaska, Arizona, Arkansas, Colorado. So these jurisdictions also have the 12 peremptory challenges, and the mark of it is a criminal defendant is facing a prison sentence of 15 or more years. So this is where the 15-year mark, the legislation the amendment for the 15-year, less than 15 years of imprisonment, that also is found in 30 other United States jurisdictions, not all of which are the same as the jurisdictions that have the 15-year and above. So the court in looking to present options to try and address our backlog of cases, this amendment being one, look to other jurisdictions as far as what they do with peremptory challenges. And that is where this language comes from, is from those other jurisdictions. And we can provide those actual listed jurisdictions and the number of peremptory challenge offered in all of those jurisdictions to this legislative committee.
All right. Yes, I appreciate that. And could you explain if the 30 other jurisdictions implemented this type of limit on peremptory challenges as a way to expedite voir dire, or were they implemented prior to any type of?
My understanding, Madam Chair, is these are all if you're asking me if were done in the pandemic, they were done before, but peremptory challenges are constantly under watch by law review articles, the more sophisticated, the bar associations look to it because they're ripe for abuse. And so there's many jurisdictions that look to eliminate peremptory challenges entirely just because of the abuse process. In the voir dire process, you have peremptory and then you have the challenges for causes. You've been told, by the public defender and the other attorneys present here, the challenges for cause are there's no number on them. The peremptory are just an arbitrary number that's thrown out by statute that allows the two sides to use. And there's many judicial wiser people than myself that look to and have advocated for the elimination of peremptory altogether. So it's not a novel, or it's not a settled issue as far as the numbers and what peremptory challenge is best. They're constantly under examination. But for our purposes, for this legislation, our amendment, we're looking, it's got a 2-year sunset provision. It is meant to address the backlog, and our judicial officers are of the opinion that it will push the case through more expeditiously if we can limit the number of peremptory challenges that are offered to each side. Thank you.
How much time do you think this would save by limiting, I don't have a total, maybe 3, 4, 5 peremptory challenges?
I think the speed in which it affects the case is how fast you put the jury in place, as far as when you actually have a jury that's been selected. So the peremptory challenges, I don't think you can put a minute mark or an hour mark or a day mark, but the faster that you impanel a jury, the faster you're going to take the case through the process. So this is one type of delay that occurs in the process of selection, is when you have the challenges, because now you've eliminated a potential juror, another one has to come in. So if you look at how we're operating under the pandemic now to stay within CDC guidance, when we bring jurors in, we can't go with the old way of seating 80 to 120 jurors, in any of our facilities right now. Not even our high capacity San Ramon courtroom can seat that many. So if a juror is struck and we bring in a new panel, it's just another delay of the process as we keep bringing our panels in. So for me to give I don't think I could do that and be.
All right. Do you think it would result that reducing the number of peremptory challenges would increase the number of challenges for cause?
No, I think that's inherent in any. I think I don't think they go hand in hand. I mean, the challenges for cause, the peremptory, there's no basis given for it, even though, there's a lot of case law out there where the peremptory was used in a discriminatory fashion. I mean, we have law books filled with that. So if anything, I think with the challenges for cause, you have to state why you're striking a juror. If anything, it probably keeps the integrity of the process in place. So, I mean, there's different sides that look at the challenges and their benefits, but the peremptory is there's no basis given, even though there can be a hidden basis and it can be argued later.
All right. Okay. Thank you. I'm going to open it up for questions from the senators. Senator Peter Terlaje, did you have any questions on Bill 410?
Like I said, Madam Chair, we're just going to have to go through the written testimony and make that determination as a group and base our determination on some of the testimonies that are being presented. And I want to thank also again the panel, and I want to thank you, Madam Chair, for bringing this up and for all the things that I'm hearing. There's some things that we need to really absorb in as far as making our decision based on testimony. And I want to thank you again, Madam Chair, for the opportunity. Thank you very much.
Thank you, Senator Terlaje. Minority Leader, Senator Taitzagui.
I have no questions. Thank you.
Senator Torres.
Thank you. I think I understand the intent of this bill, and it was explained very well, I think, by Christina Baird. So thank you very much.
All right. Thank you all, again for all those who've testified on this bill. And again, testimony on this bill will be accepted until November 6th. So I encourage written testimony to be submitted to the Guam legislature or to my email, senator.terlajeguam@gmail.com. We will now go to the fourth item on the agenda, which is bill number 411-35, introduced by Therese M. Terlaje, an act to amend section 80.60 of chapter 80, title 8, Guam Code annotated, relative to extending the time in which a defendant must be brought to trial. I'm the sponsor of the bill, so I will introduce it. Like the other three bills, this bill was introduced after receiving requests from Chief Justice Carbolito to assist the judiciary in resolving its backlog in cases due to the pandemic. The bill was discussed and included in the Judicial Council's resolution number JC 20-026, relative to approving proposed legislation on the conduct of judicial proceedings for submission to the Guam legislature, which was adopted on August 20th. So the bill, as approved by the Judicial Council, would permanently amend Hgca 80.60 to increase the speedy trial time limits for in-custody misdemeanor defendants from 45 to 60 days, and for not in-custody misdemeanor defendants from 60 to 75 days, and increase the speedy trial limits for in-custody felony defendants from 45 to 90 days, and for not in-custody felony defendants from 60 to 180 days in those cases. BBMR on this bill said increasing the time a defendant is in custody. Oh, sorry, I'm sorry, let me go back. BBMR said that increasing the speedy trial time period should result in a more effective utilization of the judiciary's resources. Furthermore, the judiciary's position is that no additional legislative appropriations would be required to implement this bill. However, increasing the time a defendant is in custody before trial will increase operational costs to the Department of Corrections to detain the defendant. Absent additional information regarding the specific costs to DOC, the Bureau is unable to determine an approximate fiscal impact at this time. So we have invited testimony on this bill from the Attorney General's Office, the Public Defender's Office, Alternate Public Defender's Office, Department of Corrections, Guam Bar Association, Guam Police Department, Guam Coalition Against Sexual Assault and Family Violence, Victims Advocates Reaching Out, and Guam Family Justice Center Alliance. We will go now to those who want to testify on this bill, beginning with the court. Attorney Baird.
Yes, thank you, Madam Chair. In addition to Chief Justice Carbolito's statement that I read earlier, I would like to read in the following. The rationale for amending Hgca section 80.60 is threefold. First, there is a growing backlog of criminal case as a result of the current public health emergency, and this amendment would aid the court in processing these cases. Second, as the Judicial Council expressed in the resolution number JC 20-026, permanently amending the statutory speedy trial time limits in criminal cases would lessen the strain on judicial resources while aiding the defendant's ability to prepare for trial. Lastly, and probably more importantly, this amendment would bring Guam's time standards in line with the current time standard recommendations developed by the American Bar Association for bringing a defendant to trial. As stated in JC Resolution 20-26, Guam's current time limits are among the shorter time limits in the nation. Accordingly, criminal defendants often must choose between waiving their right to a speedy trial because they do not yet feel ready to proceed, or assessing their right to a speedy trial and risk not being fully prepared to defend themselves. Many defendants assert, waive, and reassert their speedy trial rights multiple times throughout a case because they are not prepared to proceed to trial as the speedy trial time limits draw near. This leads to an ineffective use of judicial resources as cases are often rescheduled based on their priority among other asserted speedy trial cases. A longer speedy trial time period will ensure that defendants are not rushed to trial without adequate opportunity to prepare and will result in a more effective utilization of resources. Furthermore, the American Bar Association's standards on speedy trial and timely resolution of criminal cases, third edition, year 2006, provide for a much more realistic time period to bring criminal defendants to trial as compared to the 45 and 60-day time limits currently set forth in Hgca section 80.60. Under the ABA standards, the presumptive speedy trial time limit for in-custody defendants is 90 days from the date of arraignment and 180 days for defendants who are not in custody. That is found in standard 12-2.1. Speedy trial time limits, ABA standards for criminal justice 12-2.1. Shorter presumptive time limits are recommended for persons charged with minor offenses. According to the ABA, these standards support three purposes. One, to effectuate the right of the accused to a speedy trial. Two, to further the interest of the public, including victims and witnesses, in the fair, accurate, and timely resolution of criminal cases. And three, to ensure the effective utilization of resources. Thank you, Madam Chair, for allowing me to read that testimony into the record.
Thank you, Attorney Baird. I would just like to state for the record and recognize the continued presence of Justice Catherine Merriman throughout each of the hearings on each of these bills and on Bill 411. Thank you, Justice Merriman. And we will proceed now to others who've signed up to testify. Public Defender Stephen Hattori, Executive Director.
Thank you, Chairman. Our Deputy Director, Mr. Morrison, would like to present his testimony.
All right, thank you. Deputy Director Morrison.
Thank you, Senator. With this bill and some of the others before the committee, I think it's important to first remember that people that come before the court are presumed innocent, and in many instances are innocent. I mean, it's one thing to say it's because of a statute or the Constitution or the Organic Act, but frequently when we get into court and get a case in front of a jury, we find out that for either a small reason or an overwhelming reason that somebody's either not guilty or is factually innocent. So I think that's where we have to start, because the inquiry really is, how long is everyone comfortable with an innocent person waiting for their trial? And how many times should they have to be made to wait? There's a few presumptions that are in the intent language of this bill that I wanted to try to provide some clarity on. And the first, I think, is that there's sort of a presumption here that a case that's lost for a speedy trial reason is gone for good. And currently, that is not the law on Guam. If a case is dismissed for a speedy trial violation, there's then a further analysis that the trial court judge has to do, including asking how serious the charge was, what the reasons for the delay were, if there's any public policy reasons against dismissal for good. So there's more of an analysis here. To my knowledge, I'm not sure if since 2019, when that case established what the standard is, I'm not sure if there's been any case lost for speedy trial that the government wasn't able to just refile. I also wanted to give some background and clarity on how speedy trial works as a practitioner. There's a 45-day limit for people that are in custody, but that limit is not absolute. If an attorney does almost anything on the case other than to just ask for a speedy trial and sit back, the timelines are going to change. For instance, if an attorney filed a motion to dismiss, to suppress some or all of the evidence, or even for clarity on some of the charges by a request for a bill of particulars, that's going to delay the defendant's right to a speedy trial. And in practice, what happens is the parties have about a month to file their papers, and then the court gets another 3 months although they do try to act quickly when it's an asserted case, but they have an additional period of time to decide whether or not the motions have any merit and what sort of rulings they need to give. So unless you do nothing, the case is going to take more than 45 days. If you filed almost anything that requires the judge to consider it, that's not a trial motion, something that can be filed during the trial, the timelines here are completely unrealistic. It's going to be expanded greatly. In the intent language, there's also an indication here about defendants having to choose between being prepared or a speedy trial. And I wanted to give some clarity on that as well, because this is something that happens in practice. And I think the intent language may not fully explain that. What happens in practice is I get assigned to a case, I meet with the client, he wants to assert speedy trial, so we do it. And it's happened to me many times that we get to day 40 or day 43, we're just about to go into trial, and the government comes and says, our police officer spoke to us and there are additional notes, there's additional discovery, there's additional things that should have been discovered through the process or handed over for us to review. These can be things like the notes that the police are required to turn over. It can be things like photographs. It can be things like audio and visual recordings, things that can really upset the entire trial process. So when you're faced with that situation, you're about to go into trial, then the question for your client becomes, well, do you unfairly want to go in unprepared, or do you want to continue to assert speedy trial? We used to have case law that was very helpful on what would happen in this instance, that the evidence wouldn't be allowed in, that the case might be dismissed under certain circumstances. But now the first remedy is really to allow for a continuance. But that can only occur if the defendant waives speedy trial. So this idea is false, that defendants are just coming into court and saying, it's day 42, I suddenly don't want my trial, I want to think about it some more. Maybe that happens once in a while, but overwhelmingly what's happening here is we're getting late discovery. So this bill does nothing to solve that problem. That is a historic problem that we've had for a very long time here. Last, I wanted to say that the demand for a jury trial is not causing any backlog that I'm able to perceive. I think this is just largely in line with the comments that I had earlier, that at least in my practice, the clients that are contacting me are not demanding jury trials so much. They don't want to follow through with a jury trial. They just want their case processed through in a semi-timely fashion, and that's become a real struggle. Also, we're struck by the lack of a sunset provision here. This is an effort to just, rework something that has been on the books for decades. For I think my entire lifetime, this law has been in effect. Senator, I also wanted to point out last, and I'll write a testimonial letter to this effect, but there are jurisdictions that have lengthier time periods than Guam has. That is true. But there are many jurisdictions as well that have required that any dismissal for a speedy trial violation is a dismissal with prejudice, that it can't be brought again. So there seems to be an exchange that some jurisdictions at least have made to try to make their process fair. This just is a complete rework of the speedy trial without even considering that. Those are the comments I wanted to make. Thank you.
Thank you, appreciate that. And Anna Marie Gail, alternate public defender.
Yes, thank you. Again, this is a real important piece of legislation if you're going to go through with it. And I just don't think we've had enough time, or the bar has had enough time to vet it. And it's hard for me to even testify, because I think this is trampling way too much on our clients' rights. And I don't think one hearing is going to do it. I think we need a roundtable. This is so unfair to our clients. And we'll put stuff in writing for you, but I really wish you would just put it on the side, so we can thoroughly vet it. There are other ways to handle this backlog. We've talked about this backlog. Again, I would like to say that our clients, what we are trying to work on these cases and get them forward, but it takes a little while because the Attorney General's office, not all the prosecutors are as diligent in returning emails and phone calls, and they're shuffling around a lot, which is, you know, that's their right to shuffle their attorneys around, but we just aren't getting the work through as quickly as we want to. So I agree with Mr. Morrison, but I really would like the committee to put this on the side and let it be vetted a little bit more thoroughly. Thank you.
Thank you. From the Attorney General's office, Attorney Shannon Titano.
Thank you, Madam Chair. I'll go ahead and read into the record our comments on Bill 411. First of all, we do support Bill 411. Bill 411 represents the legislature's findings that the right to a speedy trial is of significant importance, but is not absolute. The court has also recognized that the protection of the health and safety of defendants, attorneys, court employees, and those called to jury service outweigh the right to a speedy trial. And we cite the Supreme Court of Guam Administrative Order ADM 20-413, paragraph 27, which was dated October 9, 2020. In its latest administrative order that I just cited, in its latest administrative order, the court told the time periods involving speedy trial procedures until December 31st, 2020. Despite the court's administrative order, there have been instances where defendants have moved to dismiss their cases based on an alleged violation of their statutory right to speedy trial. The resolution of these motions has required the use of both our office's resources as well as the court's. In support of both these positions, we offer for consideration the possibility of recognizing that delay caused by reasons attributable to the COVID-19 pandemic constitute good cause as a matter of statute. The portion of Section 2 of the bill amending Title 8, Chapter 8, Section 80.60 would be revised to read as follows. What I'll do is just read the portion pertaining to good cause and the language we suggest be included at the end of that sentence. And it should read, when Hgca has placed the island under pandemic condition of readiness 1 or 2, delays caused by reasons attributable to the coronavirus pandemic, examples, positive cases within the courtroom team or prosecution team, closure of relevant government of Guam agencies, setting maximum capacity levels of government agencies, mandating adherence to social distancing requirements, reduced availability of jurors, etc., shall constitute good cause. Again, in conclusion to my testimony on Bill 411, we support the measure.
Attorney Titano, does that mean that are you also recommending a sunset provision?
No, we support the measure as it is currently written. We don't suggest amending it to include a sunset provision.
All right, thank you. Attorney Ariola.
Thank you, Senator. You know, Senator, and all who are present at this hearing, the right to a speedy trial is such an important right. It's a basic, fundamental, constitutional right. It is so basic that in most jurisdictions and in Guam, you can challenge the violation of a right to speedy trial, both constitutionally and statutorily, whatever is in our statute regarding speedy trial rights. And it is such an important right because previously, before we had that right to a speedy trial, people were incarcerated for any reason or no reason. And historically, they were held without charge, without bail, without bond. We are now in a society where the right to a speedy trial is so basic and important that we need to protect that right, no matter if we are in a pandemic. And my testimony for Bill 408 applies equally well here, which is that in a time of a crisis and a pandemic, we should not be restricting defendants' rights. We should be protecting them. Most importantly, for all of you to understand, these are just not numbers of days. You know, that someone has to be brought to trial within a certain period of time, 45 days, 60 days, 75 days, 90 days. These are days in which certain of the defendants are going to be incarcerated. And what I think the legislature really needs to find out before it does anything, before it even considers this bill, is that they need to get the numbers of people who are currently incarcerated and who haven't been brought to trial, whose cases are still pending, and who have been there for months at a time, for years at a time, and who are not getting not even a speedy trial, much less a trial, okay? And these are people who are not asserting their right to a speedy trial. They've waived their right to a speedy trial, but they are languishing at the Hgca Detention Center or at DEPCOR because no one is taking their case to trial. And that's what you need to find out before you do something as drastic as changing the statutory rights of a speedy trial of a defendant's speedy trial rights. If you're not going to do that, then you'd have no basis to change this law. You know, this bill is coming in and it's not even saying, you know, because of the pandemic, these numbers will actually change the backlog of cases. I view this as a bill or a law that would not change or remedy the backlog of cases. It would just push them down further. We're going to have more people incarcerated. We're going to delay even further the speedy trial rights of defendants. So before you do that, I think you need to get more information about, you know, is the system working now? Because I don't think it is. From the experience of our firm, our clients are not being brought to trial speedily. They're not being brought to trial on time. And if they can't do that now with our current speedy trial time limits, how are they going to do that with new trial time limits? You know, and then we have that this law is going to be changed. It's been on the books for so many years, and it's going to be changed because, you know, a few other jurisdictions have, you know, longer time limits. How are these speedy trial time limits that are currently in effect, how are they not working? That's what I'm not seeing in this bill. I'm not seeing evidence of it's not working, where, you know, the defendants are not being brought to trial in a speedy time limit. But instead, we have no indication other than we're in a pandemic. We need to change the law. That's not a good enough reason to restrict defendants' constitutional rights. And then we have something that I think is super important to note, and that is that you have the Department of Administration weighing in on whether or not this will cause budgetary concerns. Maybe not for the court, but it certainly will for DEPCOR and for all the other detention facilities. So instead of a lesser time to bring a defendant to trial, 45 days for misdemeanors, right? Or people in custody, and 60 days for people not in custody, we're going to have longer time periods of people in DEPCOR. What's that going to do for the strain of resources for those facilities? So now you've just created a problem. You've taken it from the court and you've transferred it to DEPCOR. What is it, $33,000 a day now that we have to confine people every day at DEPCOR? So we're going to confine them even longer while they're asserting their speedy trial rights. How does that help us? How does that affect the pandemic when we have, you know, rising numbers of cases at DEPCOR? I would submit that this bill doesn't do anything to help the backlog of cases, and certainly not in this time of pandemic. What we should be doing is protecting the rights of criminal defendants whose rights need protection more than ever, rather than trying to restrict them. Thank you, Senator.
Thank you, Attorney Ariola. Attorney Brennan, would you like to testify on this bill, 411?
Thank you, Madam Chair, and thank you for allowing me to follow my boss, starting with the last bill. You know, I have to echo her sentiment, but I do have some very specific points. I tried to look at these bills from sort of a practical lens, and the first issue issue I'd like to raise is just why do we need this bill? Effectively, the Supreme Court did this already. The Supreme Court in March entered administrative orders suspending speedy trial, suspending prompt arraignments. They've done this already. And here we are 9 months later, and then they asked the legislature to take legislative action. And I know, our firm's experience, we have a trial ongoing right now when the positivity rate, the hospitalizations, all of the indicators that were previously used to justify delaying speedy trial are greater than they were in March. It doesn't strike me as government action informed by the data they're citing to, at least. So that's the first point I want to make, is why does the Supreme Court need to do this? And, imagine a defendant's trying to assert and protect his right to speedy trial, bringing a motion to dismiss. He has to face the same courts, the same judges on the Judicial Council and justices who made this pronouncement. So he has no meaningful way to review the Supreme Court's action. And it's just been a challenge from the outset. The Attorney General has cited to the fact that resources were expended to defend against motions to dismiss for speedy trial purposes, resources of the AG's office and the court. Well, both are deemed essential operations of the government, and that is their job. Our clients should not have to sit in jail while they're concerned about resources to defend against speedy trial motions. That is what the courts and the AG's office is there for. I'm a young lawyer, but I can't reconcile that argument with the fact that there has been no loss in pay for government attorneys, for Superior Court employees, and they try to use that to justify keeping our clients in jail. And that's just at the outset. And some general concerns with all the bills that I saved for this bill is the fact that this is an effective date on the date of passage. What does that mean for our clients? Because the court has only cited to cases since the pandemic began. There are 2017 and 2018 cases that are still pending trial, that have asserted their speedy trial, that have parts of the speedy trial clock already expended before the Supreme Court suspended speedy trial rights. So are they now looking at an increase to the speedy trial clock they've already asserted on at their arraignments before the pandemic? Are they now 180 days instead of the 45 days now allowed? The language in the bill just does not address what the court seems to be seeking, which is retroactive application since the beginning of time for any trial that's pending. And if the justification is the COVID era restrictions imposed on the court, again, not jive with the fact that we have some clients, at least in our firm, and I assume the government public defender and alternate public defender have similar situations where they have weeks left on the speedy trial clock. And so I just can't understand why there isn't any language specifically addressing whether this is supposed to be retroactive, when it goes back to, and who it applies to. Again, huge due process concern. Prospectively, this bill creates a distinction between misdemeanors and felonies. But if you look at what will occur, it'll mean that right now, if you're charged with a misdemeanor or felony, your speedy trial date is governed by the age of your case because there's no distinction drawn. It's from the assertion date. Is passed, misdemeanors will go to trial faster than felonies, and if their speedy clocks are running out, they may take precedence over felonies. So it may just increase the backlog of felony cases that court seems to be worried about. If misdemeanors that are younger and charged more recently than felonies have to go to trial in 75 days, and you have 180 days on a felony case, we might be moving misdemeanors faster than felonies, and that seems to be backward. When tells the courts to prioritize felonies, particularly those with minor victims. And the court already has at its disposal, and the government, the good cause exception. And if you look, I know the court cites to the ABA model and that, this is what some jurisdictions are moving toward. The two largest jurisdictions that I'm aware of, the Federal Speedy Trial Act and the California Speedy Trial Provision, which Guam's law is based on, are 60 and 70 days. No distinction between felony and misdemeanors generally, but it's 60 and 70 days with statutorily enumerated exceptions. And Guam courts have looked to those exceptions to use the good cause and apply the good cause exception here. But again, just because some jurisdictions have moved to these larger time periods, it really doesn't jive with what the court's asking for, which is a COVID-specific application. And I think just in closing, that goes to Mr. Morrison's comment about you know, the lack of a sunset provision. If this is just COVID specific, why is that suspiciously missing? Why is that provision suspiciously missing from this bill? Sorry, this is my final point. You know, the prompt arraignment case law, there's no specific that says prompt arraignment is 60 days. What the Supreme Court did in Roswell is they found that 60 days based on the Speedy Trial Act is appropriate. So by extending this, are we also implicitly suggesting they should extend the prompt arraignment case law that's been determined, in which case we would get double. So it wouldn't just be 90, 180, 75 days. We might be looking at double those timelines, since the Supreme Court has already endorsed the arraignment timelines being applied to speedy trial timelines. That's all I have. Thank you, Madam Chair.
So, Madam Chair.
Thank you, Attorney Brennan. Very much appreciate the points that you've made on your testimony. I could call Attorney Timingholt.
Thank you, Madam Chair. I think Mr. Brennan raised some of the points that I wanted to raise, so I'll yield my time. I think Mr. Hattori was trying to get the chair's attention.
All right, yes.
Thank you.
Yes.
Thank you, Madam Chair. I don't want to belabor the point. I think everyone's made good statements. I just want to point out things that might have been overlooked. So the ABA standards do recommend a 90-day clock for confined clients, but that clock starts once you get charged with a case. At the magistrate's hearing, it starts. On Guam, the clock doesn't start until arraignment. And so when you get arrested and you're given your magistrate's complaint, you know, the day or 2 days after you're arrested, right? The government has 10 days to indict you if you're confined. So that's 10 days. And then under the Rationale decision, the court has 2 months to arraign you. So that's 60 days. So that's 70 days before you can first assert your right to a speedy trial. And so if you tack on another 45 days from there, we're talking 115 days. Under ABA standards, if a case is not brought to trial within 105 days, that case is dismissed with prejudice. So the ABA standards, I mean, I like it because it actually adds teeth to a right, because a right with no remedy is not a right. And currently there is no remedy. You just get your case dismissed, then you get released. The government can recharge the very next day. They can ask for another bench warrant. You get thrown back in jail, and then the process starts all over again. And so, you know, I think we really do need to have some teeth behind the speedy trial rights bill. I know Mr. Morrison mentioned that maybe something like that after ABA standards of after about 105 days of if you haven't gone to trial within 105 days from the time of initial the magistrate's complaint, then perhaps a dismissal with prejudice is appropriate. And so I just wanted to point that out. The other thing I wanted to raise was I'm glad that the Department of Corrections is here and submitted testimony. They said it costs $108 a day, so that's almost $5,000 per detained client for the extra 30 days that the bill seeks to extend speedy trial. And, you know, multiply that over 100, 200 clients that are being held, and, you know, that's $500,000 to $1 million extra that, you know, the Department of Corrections does not have. And you know, a point that I think has been raised by Mrs. Arreola was that you know, if we want to reduce the backlog, you don't lengthen the time to do something, you know. And so I think lengthening the speedy trial clock will have the opposite effect of what's intended. And so we're hoping that you know, the legislature really considers this. And, you know, I think that the court's already taken measures to ensure that you know, they don't have 100 jury trials starting tomorrow, right? And we're willing to work with them to, you know, prevent that from happening. So I have nothing further. Thank you.
Thank you very much, Attorney Hattori. I would like to read the testimony from the Department of Corrections. Robert Camacho, Deputy Director of the Department of Corrections emailed to our committee, and I'm quoting, DOC receives anywhere from 5 to 8 detainees per day on average. The approximate cost for housing is estimated at $108 per day. This amounts to about $800 average per day for the average detainee intake. This does not include transportation and overtime costs. More importantly, many of these detainees may have pre-existing medical and dental issues. Most especially, those with a history of illicit drug use tend to have more serious medical conditions. Some detainees require emergency treatment from Guam Behavioral Health and Wellness Center. When an officer transports and has to remain with a detainee at Guam Behavioral Health Wellness Center, this poses significant overtime costs. We are implementing virtual hearings for detainees and the courts at 4 different locations at Department of Corrections, within the Department of Corrections. 3 of those areas will most likely have an impact on overtime costs. We pay over $4 million in medical bills and services annually, so any extended detention at Department of Corrections will add to our burden. Our overtime cost has been significantly reduced, more than the courts are able to do currently by its order, for example, with its orders during the pandemic, extending trials, closing the courthouses, that type.
Absolutely, Madam Chair. So if you look at the legislation, it's not a ex post facto. It's not going to go backwards. It's going to be forward. So as Ms. Rossetti already testified to, gave you the number of the backlog cases, those cases are now currently waiting. Once lift, and there will be a lift at some point by the Supreme Court on the tolling, once all the cases come up, as you've already heard testimony from some of the defense bar here, some of those cases have to be heard within a matter of weeks. So in the meantime, people are still being arrested. People are still asserting their rights. So this legislation addresses those cases coming forward, that those individuals that subsequently get arrested, if this legislation is to go through, it will apply to them and it will stop the onslaught of additional cases that the court has to try and address. So it's actually a very simple math. We have 7 judges that can hear criminal cases. Right now, we have 100 and something cases that have been asserted. Once the lift occurs, those cases are going to take priority between 7 Superior Court judges with what is now 1 courtroom that we have available. So if you just look at the math, you can see that this legislation will stop those other cases in which assertion has been made, and it will slow it down so that our judicial officers can address this backlog. And as I want to keep emphasizing, as some of the defense bar have noted, there are some of these cases that once that lift occurs, they have to be heard in days because of the assertion and the defendant's right to speedy trial. So this legislation stopped, or at least stretches out some of the timelines for the cases that are still coming down the track.
All right, and the current law does not distinguish between felony and misdemeanor, but this bill would differentiate between the two. Could you just explain the rationale behind that?
Yes, and where once again, where the amendments came from were from the other jurisdictions that we researched, and I would like the opportunity, the court would provide that to this committee, showing the other jurisdictions that have similar provisions. But for the misdemeanor cases, for the felony, as far as when there are times, if you look at the change in the legislation, for the misdemeanor cases, it just simply added on a 15-day period. If you look at what all the other bills are in front of you, what we've stated all along is with the misdemeanor cases, we can hear those cases within our courtrooms right now because they don't read those cases. We only have to have our 6-person juries. So they can be put into our courtrooms currently now. Our big concern is the criminal felony cases that require a larger jury panel and a larger panel to go in which we only have 1 courtroom. So when you look at the timelines here that are presented, the misdemeanor cases, there was a simple add-on of 15 days into those. With the felonies, The days are longer, you know, everything all relates with the jurors that have to come in, the amount of jurors that are impaneled, and then just our facilities that are available to address these particular cases.
All right, thank you. I'm going to open it up to senators now. Senator
Thank
Peter,
you.
Senator Peter Terlaje.
I just want to thank Madam Chair. I want to thank Attorney Rula and Attorney Brennan for their input. I couldn't agree wholeheartedly with what they were saying, and I know there's some issues regarding confirming to what we need to do. So especially the expense that is going to affect the Department of Correction, and we need to work on that, Madam Chair. And I'm fully supporting you on these bills, and we'll make the changes based on the amendments that are being made by the panel. So I want to thank you, Madam Chair, for your input too, and in expediting these bills. Thank you very much.
Thank you. Senator, Minority Leader, Senator Taitabui.
Thank you, Madam Chair, for the opportunity again. And I'd like to also thank the Honorable Catherine Merriman, Chief Justice too, that's been here all day long. I greatly appreciate it. And everyone else there, thank you so much. You know, great time to have Justice Barrett to come and give an opinion on this too, huh? But I think the important thing, no, yes, she would be a great person to bring in. But anyways, you know, I have with regards to the bill itself, I mean, you know, doing a little bit of research on this. So the question is to the court, you know, can the court set these time limits through its own process in establishing its rules or procedures? Like some jurisdictions like Arizona and Washington, it's the court that sets these rules and not the legislature.
Senator, this is a constitutional right that belongs to the defendant as far as their right to the speedy trial. It's not the court's right. So the court couldn't do that without tromping on the constitutional rights of the defendant.
I see. Okay. Thank you for that. And I really appreciate everything that the courts are doing right now, considering the pandemic that we're in, the situation we're in, and, you know, trying to think outside of the box to try and assist the court to be, you know, to do their job and do it well. But I think too, you know, I think some of these bills could use, you know, additional conversation to discuss this further. And I appreciate all the testimony that was here today. I'll take everything into consideration and look forward to maybe this round table that many of us talked about earlier. So thank you, Madam Chair, for the opportunity.
Thank you, Senator Taitabui. Senator Mary Camacho Torres.
Madam Chair, I was just wondering, the court, you know, there's a lot of discussion about criminal defendants here and the rights to a speedy trial. But how will this bill and extending the time frame affect all other matters before the court and the adjudication of all come before the court? Because while there are criminal cases, you know.
Sorry, Senator, you're breaking up.
Across the community.
You were breaking up. If you could repeat your.
How does this bill affect all of that? What would be the? Okay, I'll try again. I'm sorry, my internet must be a little spotty in the south. The question that I had was, we are talking a lot about the rights of criminal defendants and the right to speedy trial, but my question is, how will this bill impact all other cases before the court that also need to be adjudicated, the civil docket, anything that really affects the lives and the livelihoods of the everyday person in the community? So taking aside the criminal defendants, what benefit would this bill have to all other cases and all other people in the community that have matters before the court that need to be adjudicated? I'm just wondering.
That's a good point, Senator, because the speedy trial cases, the criminal docket has to take priority over all other cases. So when we have an assertion, that case goes first on the docket and all other matters are heard later. So and if we're looking forward and we're allowing the court to address the backlog, and if speedy trial rights that are asserted are given extra time, then the court does have the opportunity, to look at other cases and to address those other cases. But right now, looking at the backlog, looking at how fast these cases are going to, once the tolling stops, right now our priority at the judiciary would be the criminal cases, and we anticipate all of our judges are going to be absorbed in those cases. But the bill does in the future help allow the court to address other matters.
Thank you. So there is a benefit to all other people with matters before the court is the short answer to extending the statute, the tolling timeframe then. And that's essentially what you're saying.
Yes, Senator, thank you.
Thank you, Madam Chair.
Thank you, Senator. Attorney Barrett, could I ask an additional question? It's been stated that this bill would cause Guam's statutes to exceed the ABA recommended standards of 105 days. Does the judiciary have a response to that?
I'm sorry, you're breaking up. I don't know. Can you ask that again, please?
Yes. It's been stated earlier that this bill would cause Guam's timeline to exceed the ABA standards of 105 days. Is there any judiciary response to that?
Yes, if I may, Madam Chair, right now, Guam's proposal with misdemeanor in custody is 60 days. The ABA recommendation is 90. The misdemeanor with no custody, Guam's proposal is 75. The ABA's recommendation is 180 days. Felony custody, Guam's proposal right now is 90. ABA recommendation is 90. The felony no custody is 180. ABA recommendation is 180. So right now, what my research shows, Guam is in parity with ABA's recommendation on both the felony custody and no custody, and is actually less than what the ABA recommends for the misdemeanor. But once again, we can present our charts with our jurisdictional breakdown of how our jurisdiction and the ABA recommendations are the committee. But from my research, we have statutorily proposing less days under the speedy trial time clock for misdemeanor, and we are right on par with the ABA's recommendation for felony, both custody and no custody.
Okay, I understand. But it was suggested earlier that if you calculate, beginning with the magistrate's complaint, that the time periods would then, the total time periods would exceed. So if you could, when you submit your analysis, just include that also. I would appreciate it.
We will. Thank you.
And then, does anyone who's here present believe that extending these timeframes would impede the constitutional right? I understand all the reasons that it may not be advisable, may not alleviate the backlog of cases at the judiciary, may actually exacerbate it. But would these time periods be within Sixth Amendment acceptable time periods? Attorney Timing.
Madam Chair, I think that question asks something that's a bit longer to answer. Under our Guam analysis of speedy trial rights, there are two analyses. One is the statutory, which is part of the subject of this bill. The other is constitutional. And so for either one, it appears, if my recollection of case law is correct, that no one finds a problem with speedy trial violations in the court system unless it's more than a year of a violation. So I have had a case where there was a delay in 100 days and there was no violation found. I've had a case where there's a 200-day delay and there was no violation found. So to say that this is just a 15-day increase, for example, it's incorrect. That's 15 days after motions, after the delay in arraignment system, after motions are decided, after continuances for constant late discovery from the AG's office. Then from there, let's say we get our trial, which has already been pushed to day 140, for example. There will be no speedy trial violation found on the appeal level, if my recollection is correct. Now we get up to the 200 range. Now we're a little closer, but there's no finding of a constitutional violation presumed unless it's after 1 year, generally speaking. So these are not just 15-day increases. These are drastic increases, especially when you consider that if I'm arrested in March and the speedy trial tolls all the way through, I'm not getting into a courtroom until December or January, for example, then that's right without a remedy, as has been said before. So even if we weren't in current lockdown times, that right is generally pretty squishy. So it's not something that's guaranteed where I'm going to get my trial in 45 days. And if I don't, the government can refile it again, start the whole process all over again. And it's just a constant cycle.
Thank you so much, Attorney Tamango. I noticed while we were having our hearing, there are a couple that have appeared. Were you intending to present testimony, Ms. Rojas?
Thank you, Madam Chair. Good morning. I did want to just touch a little on Bill 411-35. I apologize to the other senators and anyone else who is present this morning for tardiness. I was in court, so I don't know where we are really in our discussion. It sounds like maybe we've gone through all the testimony.
We have, but if you would like to state any testimony on the record, you are welcome.
Thank you, Senator Terlaje. I can just say really briefly, because I know our office will submit written testimony. I am an assistant public defender, and my testimony was really directly towards Bill 411. You know, as a public defender, I sit with and we represent, I myself, just under 100 criminal defendants each year, and these defendants have rights that must be protected. Bill 411 specifically attempts to take away or really extend the speedy trial right. To answer that earlier question you had, a defendant in a criminal case has a right to a speedy trial under the 6th Amendment of our Constitution. There are no set number of days in the Constitution that is listed. So whether or not the legislature decides to adopt this bill and enact it into law or withdraw it, the effect really is to the defendant. Many of the defendants that we represent do take responsibility and agree, to the charges that are filed against them. Others, and I want to sincerely just tell a story, is, there are people who are innocent, people who are accused of crimes, and this bill really hits home for these individuals. these individuals who are incarcerated for very serious, heinous crimes, first-degree felonies, if this bill is enacted into law, they will sit in jail, incarcerated for an extended number of days until they are able to have their day in court. This pandemic has seen the court unilaterally issue administrative orders to extend and really toll the rights of the defendants already. So we have seen the court's power in effect. This bill, if enacted, will extend those time periods. Someone who had a right to speedy trial for a serious first-degree felony, for example, had a right to speedy trial within 45 days will now go to 90. And, that really affects an individual. 2 days in jail for someone is a lot of time. And I'm sorry, I said I would be brief, but I am passionate about the issue. We have seen those who are accused innocently sit and wait for trial. And that is what I ask this legislature to consider and review when looking towards adopting, I guess, this measure. It will really extend, I guess, the days that some people may sit in jail waiting for their trial. I'm sure there was much more said, and we can submit written testimony. Thank you, Madam Chair.
Thank you very much, Attorney Rojas. Mr. Hgca, did you want to submit testimony? All right. There being no further testimony, I'd like to close on this bill. Again, I want to thank all of you for your testimony. It's been very helpful. And again, I introduced all 4 of the bills in the exact same language as proposed by the Judicial Council, by the Chief Justice, in an effort to assist the courts in alleviating a backlog of cases. And I think we've learned today that the real root of the issue may be the limited ability of the courts to physically, or the facilities to conduct 12-member jury panels, to bring in jurors to conduct voir dire. And we have also heard today other suggestions as to how the court might be able to deal with those limitations. And I am, of course, very open to any additional suggestions as to how we can help the courts alleviate backlog that they might have now, or that they perceive they will have when other restrictions are lifted. And of course, I am very concerned about the Sixth Amendment sections that have been raised today, and I will take those into very serious consideration. And we need to strike a balance between helping the courts administer justice versus impeding on any rights, or holding persons in prison any longer than they need to be, or adjudicating their cases as swiftly as we possibly can, despite the pandemic and despite all indications that we might, have these types of requirements of social distancing for quite some time. So again, your testimony has been very helpful. I appreciate it, and all testimony is welcome. I'm setting a time limit right now of November 6th, unless further word is made. But right now, the time limit's November 6th. You may submit it to the Guam legislature, to Senator Terlaje, or send it to my email address at senatorterlajeguam@gmail.com. Again, thank you all, especially Justice Merriman. Thank you for being here. Thank you to all representatives and stakeholders of our justice system. And thank you to the senators, again, who were present today. There being no additional individuals to testify, the committee will continue to, the hearing is now adjourned. It is 12:07 p.m. Thank you very much.
Thank you, Senator.
Thank you.